Good evening, and welcome to the monthly meeting of the Arlington County Board of Zoning Appeals, which is also known as the BZA. I'm Charles Smith, Chairman of the Board. The Board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Judy Freshman to my left, Enta Malice to my right, Paul Melnick to my far right, and Mr. Peter Owen to my far left. Also present is the professional staff, including Stephen Rissy, who's the coordinator of the Board of Zoning Appeals and serves as our secretary. I also see in the room Blake Bowen, who's assistant to the zoning administrator, and Michelle Rogers, administrative technician. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in a silent mode. On the front table, you will see a reference copy of the application package, including the staff report for each case before us this evening. I recommend that if you have not yet seen that report for your case, that you review that reference copy of your case before your case is called. We ask that you kindly return the copy after you have reviewed it so that others may have the ability to also review the case. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the Arlington County, in the county zoning ordinance, which is adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of the decisions of the zoning administrators. There are some other powers that we have which are more obtuse, but those are the main powers that we exercise on a more regular basis. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. A strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant, and that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, and that the condition or situation of the property concerned is not of so general or recurring nature as to make reasonably practicable the adoption of an amendment to the ordinance. That granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the Board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so that their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the edge of the dais. After we hear from speakers for and against the proposal. The board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient: 20 minutes for applicants, applicants of appeals, they're really appellants, 5 minutes for applicants of use permits and variances, and we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient time. After the board has gathered all the information we need and discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case is heard, you are welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening, and I'd like to ask Mr. Rissy to please call the first case.
Case number V-11338-17-UP-1 is a use permit request by Haja Zahid and Zahid Yusuf, the owners, to permit a rear setback of 0.1 feet to the eaves of an existing accessory building, garage, instead of 10 feet is required, regarding an existing garage in the R6 zoning district, premise known as 3140 17th Street North. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. 2 alternative proposed resolutions have been provided if the BZA should decide to approve the request.
Thank you. Are there any questions of Mr. Rissy? Ms. Malice.
Is this package relevant to this case?
Yes, this was there's supplemental material to this case that was handed out at the beginning of the meeting. I believe it's this supplement that has 7 tabs in front of you.
Who submitted it?
The applicant's agent was raising his hand.
Another question?
Go ahead, Ms. Malice.
In one of the letters of concern regarding this item, there was a discussion of building codes as it relates to fire.
Yes.
Do those apply to zoning issues like we're hearing?
It can have relevant bearing, I guess, yes.
Yeah, so we can consider those.
Sure.
Any other questions of staff?
Yes, Mr. Chairman.
Mr. Owen.
One of the neighbors has written in regarding the new survey that was contained within our packet that we got before we arrived tonight. And there's a quotation in the neighbor's letter from the April 16th BZA meeting that includes a discussion of the type of survey sought by the BZA. And terms that we used in that discussion included, quote, wall check survey and improvement location survey. And I'm not expert enough in this area to know whether there's a difference between those two or if they're the same thing. Could you clarify what kind of survey was included in our packet and if you believe that that survey was what we had asked for when we ruled on the deferral?
Yes. The plat is labeled as the garage location plan. It appears to show the location of the improvements on the property. It also appears to denote the distances from the accessory building to the property lines. The 2 different plats that were discussed were wall check plats, which are typically showing the distance of newly constructed walls, particularly foundation walls when they're put in. And an improvement location plat does just that. It shows the location of the improvements. In this case, this plat has shown the location of improvements on the site and is denoting the distances to the property lines of the specific elements that are in front of the board.
So it sounds from what you're describing that an improvement location survey would be, the wall check survey is just describing something that happens at a certain point in the construction process.
Correct.
And that after you've finished building everything, a wall check survey doesn't really have as much meaning because it's the finished building that you would want to know the location of. Is that right?
Correct.
Okay, so do you believe that the survey that we got is what we were asking for?
I believe it's what you were asking for, but ultimately I leave that up to you to decide.
Okay. And I have some questions about, like Ms. Malice, about the building code issues, but I think I'll hold off for now.
Thank you, Mr. Owen. everyone. Any further questions, staff? Hearing none. I think
Thank you, Mr. Chairman, members of the board. For the record, I'm William B. Lawson, Jr. I represent the applicant. I would ask if you all would follow along with this package as I present our case. The first thing is a picture of my former garage. It now belongs to my ex-wife. And the reason that's important, it was built many years ago, and the wall is exactly 1 foot away from the property line. However, you can see that the eave is closer and the gutter is closer. And the importance of this picture is that's the way it was done for many, many years until fairly recently. I think when Drew Noxon came is when they started measuring to the eave. The second tab that I have is a letter from Delashment. That was who we had do the survey work, and they're explaining why it is so difficult to do surveys in Lyon Village. And I don't exactly understand it, but apparently the record plat that got recorded all those many years ago by Frank Lyons doesn't conform with what's out there in the field. And so I had Delashment do a lengthy letter explaining why this was so difficult and why my client misunderstood where the property line was. The third tab is a whole group of surveys that the applicant found and located. And, I would note that the staff report, it says denial, but yet when it goes through all the tests, we meet most of them. The reason these are important is they show, conditions throughout Lyon Village, how close some of these outbuildings are. And a lot of them point, they talk about where the wall is. And we have no idea where the eave is. The eave could be much closer because, like I say, back in the old days, we just simply didn't care where the eave was. We measured to the wall. I think also what these surveys show is that the zoning office is not always consistent with imposing the correct setbacks for the rear yards. You can see that in some instances, even some recent ones, the rear yard was violated with some of these outbuildings. Let's see, the next tab was a couple of BZA cases. We're not sure which of these were approved. We do know that the Mewman case was approved. It was a couple months ago, and that went to 0.1 feet, and that was for a much larger structure than this, and had a bigger impact than this. Tab 5 is pictures, and they show that this is a modest garage. It's a small garage, as many in Lyon Village were back when the subdivision was built out. Very well screened. There's a maple tree that's in front of the garage that is my applicant would like to preserve. And then on the left side of the garage, there's some piping, and we wanted to point these things out. Tab 6, and this gets into the building permit, into the building code. Mr. Erickson and Ms. Williams, they're our immediate neighbors. They pointed out that the garage is not fire rated. He is correct in that. I went to my architect, Mike Stevens, and I said, well, what do we do? Now, there's a condition that says we have to get a building permit, and that's where this would become relevant, because we've got to go get the building permit. To get the building permit, they're going to make us do some things. One of the things they're going to make us do is they're going to make us fill in the window. And so I talked to my client, and given the fact that we're going to have to do some alteration to that wall, I said, look, if you got to mess with that wall, why don't we just move it so it's a foot back, and that takes care of some of the issues that you all talked about the last time this was heard. So I'd like to state now that should you all see fit to grant us some relief, we are perfectly willing to make it so that with this new property line that was created by Delashment, that we are 1 foot off to the eave. And then what I did on tab 7 is I had some suggested language that could be added to the condition indicating what we will do to make this firewall compliant. That is my presentation. If you would like, I can talk a little bit about the survey and why we did what we did, if it would be the board's pleasure.
There are questions? Ms. Malice?
I would be interested in understanding your input on the survey.
Okay, here's what I did. I went to DeLashman and Associates, and they've been doing survey work in Arlington since, I guess about 100 years. And they have records that go back generations. And so I went to them, and I said, I want a boundary, not a guess, not an estimate, not a house location. I want a boundary of the common property line. And so when they did that, and I'm not 100% sure I understand it, apparently the angle is slightly off, and it complies with our neighbor's survey. And so they had to slightly alter the angle, and that shoved the line closer to the garage than my client thought it was. But based on their best judgment, if you read the letter, you can see they had to make a couple judgment calls. But based on their judgment, this is in fact where the boundary is. And it makes the garage a little closer than we thought. However, to get a building permit, we've got to alter that wall anyhow, so we decided we would move it back.
Thank you. Any further questions of the applicant?
Yes. So there's some discussion in the neighbors' letters about whether or not the relief we're granting would apply to the shed.
Shed's being removed.
Yeah. So do you have any, does your client have any concern with clarifying in our motion, if we were to grant this, being extra clear that we're talking about the garage and not any other structure?
We would be fine with that.
Okay. And can you speak to whether or not you, I guess this is where I probably should just go ahead and ask staff, but if you have an opinion, I'm wondering, do you feel like your client needs to get a building permit does he need to get a building inspection and building permit?
Yes, he needs a building permit.
And so it would be impossible typically to get that permit if there were.
Could not get a building permit given the current physical circumstances of the garage.
Because I think some kinds of outbuildings in Arlington are exempt from building
No, I
permits.
looked at that. If this were just built, I think it's exempt, but since he added on to it, he should have gotten a permit.
Would your client have any objection to us including a requirement in the zoning ordinance that a building permit be obtained?
No, I think that condition's there, is it not?
Okay, great, thank you.
In the proposed resolutions, it does say he'll get a building permit.
And you're saying your client would be satisfied with a 1 foot to the eave
Yes.
variance? Okay, thank you.
Yes, we think, Mr. Owen, we have to alter that wall anyway.
Yep.
And since you've got to do it, we just as well move it and accommodate, make it a little easier for them so that they aren't worried about the fire reaching their garage.
Okay, and just so you know, the Mewborn application was granted with neighbor consent.
I know. I was involved.
All right.
Any further questions of the applicant's representative? Mr. Melnick?
Yes, Mr. Lawson, so you were saying, in addition, you'd be willing to add the conditions, I believe it's tab 7, about the fireproofing or the making the walls fire resistant?
I don't think it's necessary because it says we'll get a building permit. However, I did draft this so that our neighbors would recognize what it is we're going to do, so that it would protect their property from, the unlikely event of a fire. So I'm willing to add that to the condition.
Ms. Malice?
So this, if the building if the neighbors had no issue with this, would there have been any action taken on part of the applicant? In other words, it's an existing situation.
I don't understand the question. I'm sorry.
The purpose of the application is to permit an existing condition.
Yes, ma'am.
Okay. So if the applicant doesn't get a building permit,
Mhm.
what would happen?
If they don't get the building permit, I guess they could be cited for having built a structure not in compliance with the fire code.
And then they'd come back to BZA.
No, they may not come to the BZA. They'd either have to comply or go to the Building Appeals Board.
So a year from now, if a building permit has not been applied for, they would be cited.
They could be, yes, ma'am.
Okay. And then the penalties would be,
I don't do as many appeals before the Building Appeals Board. When you get cited, you likewise have,
but wouldn't it be, they would be out of compliance with zoning, because if we have a condition that says that they have to.
they'd be out of compliance with both.
They would be out of compliance with zoning, so zoning would have to cite them as being out of compliance.
Correct.
Because, I'm just want to make sure that we all understand, everybody understands the motivations and the penalties. Okay.
Okay.
Thank you very much. We have two speakers signed up to speak in favor. Deborah Diffie, and following her will be Katie Miller. Welcome.
Thank you so much. I live across the street at 3150 17th Street North,
150.
and I am just here to speak in favor of the applicant's request. I have no issue with it.
I'm sorry, 3150 17th Street?
That's it?
That's it. I don't think that it causes harm, and it's certainly not visible from the street. So from an aesthetic standpoint, there's a privacy fence, there's some greenery, and I just don't think it causes harm in light of the discussion from the representative with regard to the changes that they're willing to make. Thank you.
Thank you very much. Thanks for coming. Katie Miller of 3145 17th Street North.
Good evening. Thank you. Hello, my name is Katie Miller, and I'm a neighbor of Hajra and Zahid. I live at 3145 17th Street North. And this is diagonally located from their home, and I'm here to support their request for the modification to their garage. Each situation is different. In this instance, Hajra and Zahid wish to make minor modifications that allow them to remain in their existing home, but allow for an additional option as their needs have changed. The small bump out of the existing garage they're requesting is rather minimal and will not change the aesthetics, flow of rainfall runoff, or the health and safety of the neighborhood, as noted in the June 15th, 2018 staff analysis. Is there not a way for the Board of Zoning Appeals to allow in this very specific cases a variance that shows no harm without setting a precedent to allow for those whose proposals would do harm? I hope in today's day and age that we can work together on these issues in a reasonable manner. There are pros and cons to the many ways we seek to build and alter homes to fit today's lifestyles. In instances like these, when a homeowner, a respectful and mindful homeowner, is seeking to make minor changes that the Board of Zoning Appeals has stated will do no harm, I hope that a resolution can be found. Thank you.
Thank you. Next up, signed up to speak against the application, Markham Erickson, 3147 Key Boulevard, Arlington. Welcome, Mr. Erickson.
Thank you. Good evening, members of the board. Applicant's revised survey shows the non-conforming garage accessory building to be approximately 1 inch from our property, 0.1 from the eave, and 0.5 from the garage wall. This is a significant departure from applicant's prior submissions and representations to the board. We agree with staff there is no precedent in our neighborhood for this distance, and we therefore agree with staff that the applicant's proposal should be denied. As we say in our June 11th letter, however, the 10-foot setback is in place for many reasons, but among them are safety reasons. Virginia's residential code mandates that any wall of an accessory building that is less than 5 feet from a property line be certified as fire resistance rated and prohibits any accessory building less than 3 foot from a property line to have a window. The concern, of course, is that a garage with a window so close to the adjacent property could catch fire and damage the adjacent property. In our case, the 0.1 eave is next to a natural wood fence that connects to our garage. In addition to the precedential reasons why the application before you should be disapproved, therefore, there is a tangible health and safety reason for disapproval, and that threat exists so long as the property is permitted to remain 0.1 from the property. Applicants acknowledge they have a by right option to expand their garage. They have an approved building permit for a structure on the other side of their property. We do not believe, therefore, that it's necessary to approve any expansion of a non-conforming building. We'd also say that allowing the building to exist for the time it takes to get a building permit, and whether they do that a year from now, continues to allow a present health and safety condition to exist. Thank you.
Any questions of the speaker?
I do have a question.
Mr. Owen, and followed by Ms. Malice.
Yeah, you got, I'll defer to Ms. Malice. Okay, so we just heard from the applicant's attorney that the applicant would be satisfied with a use permit that does not permit building within 1 foot to the eave of the garage. And I think you might have heard discussion that the garage cannot stay unless it meets all building codes, which would include the fire rating. What's your reaction to hearing those things?
Well, the building, it's not as if this is an application to approve what will be done. This was done, and it creates a present dangerous situation. And so the 0.1 to 1 foot, there's no timeline for that. So the board would be approving and blessing a current danger with the promise that at some point the construction would be taken down and moved. If there were an indemnification agreement by the applicant for any damage that happens in that time, that might be something we could do.
But so it sounds from the answer you just gave that if, not that this is feasible, right? But if the wall that's an inch away were to be torn down this very night, right, and that nothing new would be built closer than 1 foot to the eave, and with the building code fire rating, would that satisfy your concerns?
I think that would go a long way to doing that. If there's some timeline like that and some indemnification in the meantime, I think that would probably work, although there is the by right option on the other side. It would be easier for everyone if that were the course of action.
Thank you.
Well, Ms. Malice?
Of course.
Mr. Erickson, thank you.
Happy to.
So the indemnification that you mentioned would be an agreement between private parties?
Oh, I'm not sure how it works. I mean, the problem is if there were a fire, our fence is actually, our garage is very close to our other neighbors. This is where 3 properties intersect. It'd be hard to understand how you would be able to indemnify the entire situation. And our garage does have it's close to our other neighbor. We do have a fire-rated wall. We don't have a window. We did that before we built the garage.
Right. So would you be looking to us to figure out the mechanics of indemnifying you? Or
And this is,
more time to figure out, how indemnification works?
perhaps there might be some time to let us try to negotiate that out.
Okay.
Thank you for the question. Any further questions of this speaker? Hearing none, thank you very much, Mr. Erickson.
Thank you.
Next up, Meredith Williams, also of 3147 Key Boulevard. Welcome, Ms. Williams.
Mr. Owen, at the April meeting, you asked me how am I harmed by the applicant's expansion of his already non-conforming garage an inch from my property, and that was a great question. I responded that being only an inch between us, it's foreseeable that all it would take is a big storm or roof repair, and his structure would actually be on my property, and I wouldn't be here in front of the BZA. I'd be filing a civil suit in Arlington County Circuit Court. But I've thought a lot about your question since we saw you in April, and I've done a lot of research. And what I learned is that the harm to me is much more serious than that. And he expanded his garage, and he added a huge window that's basically on my property today. And he did it all without getting proper permits. His changes don't meet the fire safety code under Virginia law. When a fire breaks out in his garage, or from some car oil or flammable liquid, the garage goes up in flames, his shed goes up in flames, the oxygen from the window pulls air out of that window, lights up the fence, and puts my home at risk and the other 2 neighbors that adjoin that corner of his property. All of this is completely foreseeable today, and all of this is preventable tonight. In fact, there's a huge house fire 3 doors down from the applicant a year ago, and the family is still displaced, and the home is still uninhabitable. So the danger to public welfare here is real. And tonight, I'm asking you to exercise your duty of care and to protect the public welfare from this harm and to deny this application.
Any questions of this speaker? Mr. Owen.
I would just have the same questions I had to the previous speaker, which is, do you have any reaction to the applicant's willingness to, I guess, demolish the current portion of the garage that's closer than 1 foot and to not build closer than 1 foot to the eave and to get a building permit that ensures that whatever is built meets fire code?
Well, I think part of your mandate is that if someone has a by right option, then there is no need for use permit. So I think that would be my position. And then the other thing that I would point out is that, I was here in December, and I was here in April, and I am here tonight. How many more times do I need to come and talk to you and plead with you and on different angles? I mean, the question that you posed to me in April really struck me as the core issue, and so I gave it a lot of thought. And I just, I think we're sort of at a point where we don't really know. The application from October is very different from the carryover and the carryover and the carryover, and then currently we have a carryover with another modification. So, and now we have a survey that it actually is 0.1, which actually demonstrates the same distance that I provided to you in April, but we didn't reach a resolution in April. We got another survey that just demonstrated what I already demonstrated in April. But so I'm not sure that I have no confidence that, I have no clarity on what it is that I've actually sort of have empathy for you tonight, because I think it's a difficult role that you have tonight because it's unclear what's even before you to vote on. And you also have a serious legal violation of the Virginia Code, and now you and the applicant are on notice that there's gross negligence, and if something happens to that property between now and the building permit, that is, it's not even something that you appeal in Arlington County Circuit Court. I mean, that's tort liability, and beyond that, it's just more serious than that. Look at the family on 17th Street that's been out of their home for a year. That's what could happen. That's what happens when you build and don't ask for permission first.
Thank you.
Tim May, 3136 North 17th Street. Welcome, Mr. May.
Hello, thank you. First, I'm the person who wrote the letter about the garage plan survey, so I'd like to explain my thoughts. At the end of the last hearing, the board had counseled the applicant about being forthright, and then there was some exchange of discussion about the 2001 survey. And then the board entered a specific order, and it directed the applicant to obtain, before this hearing, a full survey for the, I quote, the whole property covering all structures with measurements. And that was in a formal motion. And we had hoped that full survey would help clarify our density concerns, But instead we got the garage location plan that does omit other structures and other measurements that are on the property. And I know the board limits its review to the specific application at hand, but as a neighbor, there's a broader history, of course, that here for us. And for us, that broader history includes, unfortunately, the applicant challenging our property lines when he built his shed onto our property, ignoring the setbacks in multiple instances when he expanded his not only garage but also his house, and even disputing the professional survey that we had obtained before when we were trying to replace our fence. So when the applicant decided to not comply with the full survey requirement, that just added to our concerns about the truthfulness and the accuracy of the record. And so we're concerned about how this garage might be used in the future in its expanded state, and we're concerned about also how this garage, as expanded, might fit in with the current plans that might be going forward. So I'll stop here, but those are the reasons for my objections.
Any questions of this applicant?
Thank you.
I guess I'll ask one, and it's the one that Mr. Owen asked to the other two speakers. Is your objection, notwithstanding what's been proposed in terms of modifications?
Well, I'm not quite sure exactly what has been proposed in terms of modifications because I haven't had a chance to really, digest what those plans are. I also understand there are some additional plans for a new shed that hasn't been shared with us. We've reached out to the applicant, but we haven't had any, reciprocal, exchange of information. So we're, in the dark in terms of what they might plan to do. And we're also concerned about how all that fits in with other additions that have been put onto the house that go into the setback closer to our property line. So there are multiple things for us to digest in this regard.
Thank you. Ms. Malice.
So, obviously a remedy for, if we thought that the survey was inadequate, a remedy would be to defer this item and ask for another survey, or if you needed more time to digest what was being proposed, that would be a deferral. And yet we also heard from a speaker before you that they're getting kind of tired of coming before us.
I could second that.
So, are you suggesting that we take more time, or are you?
I'm expressing the reasons for our concerns and why we feel that we're not confident in what the record is today. And it's hard for us to tell you right now that we have comfort going forward with a proposal that might be on the table when we've had repeated concerns over the last year or two.
Thank you.
Yeah. Thank you.
And the last speaker is Jessica Bowman, also 3136 North 17th Street. Thank you for being here.
So, thank you for allowing me to speak. I will be brief because I think a lot of the points have already really been covered, but my opinion is that it needs to be denied for three reasons. One is density, which has been discussed, by right option, and also truthfulness. So the density issues are not for us, just with the garage, but also with the shed, also with his stoop, which is not before you right now, but there are multiple areas around his property where he has gone into the setback without permit, build what he wants, and then does not want to remove or rescind them. He does have a by right option, and I see no reason why that should not be utilized. That should be the go-to. We should not bear the burden of his lack of using the area that is available to him. But the third and the most concerning one is really the truthfulness issue. And the applicant has repeatedly misrepresented facts before this board. His initial written application improperly stated that he purchased his property with the garage bump out already in existence. In the December 20th hearing, he stated to Mr. Owen that the only thing that he did to his garage was add the windows and the roof. However, it was during the April 16th hearing that the applicant very reluctantly finally admitted that he himself had built the bump out. So these truthfulness issues, they're with everything with the property. We feel that whatever he agrees to now, I mean, who knows what's really going to actually materialize, because as you can see, there's a lot of disregard for just being truthful, and that's concerning for us. So density, buy right option, truthfulness, and candor, even in front of this board, is a serious concern. Thank you.
Thank you. There are no more speakers signed up to speak on this matter. I would give the applicant's representative an opportunity to clarifying points in light of what's been said, and then the matter will be with the board.
Thank you, Mr. Chairman. When I gave DeLashman their instructions, I was working off of the letter, and what the letter said was that we were to produce an improvement location survey by a Virginia licensed surveyor showing the distance from the garage to the boundary line. And so at great expense, I had DeLashman, do a boundary survey for this one boundary, because I thought that's what was important, was to make sure we get that right. One of the things I'd like to share is I believe, and I don't swear to this, I think this garage may be non-conforming. And so it was put where it was put before today's zoning ordinance, and the thing is just really narrow. And so in order to use it, you got to be able to open the doors, and so that's why the bump out. And so, I think it is necessary there be some relief so we can open the doors and not have to just tear the thing down and totally go into the yard. And then the third thing is, as far as the concern that was expressed by Ms. Williamson, Mr. Erickson, in the past, there's been a couple of times where you all have ensured compliance through the posting of a bond, and we would be willing to do that. I didn't produce a bond, but maybe we could say something such as we would post a bond in the amount of $2,000 upon terms and conditions as approved by the zoning staff, something of that nature. Thank you, Mr. Chairman.
Madam, Mr.
Ms. Malice has a question.
Could you clarify the purpose of the bond being?
I'm sorry?
The purpose of the bond being?
To ensure that he, in fact, complies with the conditions. The BZA is authorized under state code to impose a bond to ensure compliance with conditions.
I think we have other enforcement mechanisms.
You do, but if the neighbors really want to make sure he does this with due diligence, that's one way to do it.
What the neighbors are concerned about is the indemnity. That bond does not address that issue, right?
Yeah, the indemnity, I don't know how we would do it in that manner.
Mr. Chairman,
Mr. Owen.
I have some questions for the applicant's representative. Earlier, I thought I understood you to say that the applicant is prepared to demolish part of the garage closest to the property line.
Yes, sir.
At least back to 1 foot to the eave.
Correct.
And then would your client then still be otherwise building out within the footprint on the survey?
Well, all he would do is take that.
I'm sorry, if I could
wall.
just clarify my question.
Okay.
So one of the recommended resolutions in the packet that you've seen, which is pretty standard language that we have most times from staff, is that what gets built will be in conformance with the footprint on the plan.
Yes,
right?
sir.
And so I'm wondering, is what you're offering to subtract about 10 inches from the south side of the structure, and then the rest of it would still fit within the footprint?
Mm-hmm. Yes, sir.
Okay. So not to move the whole structure a foot to the north,
No, sir, he would just move
Just
the
a-
one wall.
just to clip it? Okay. So my next question is, how soon is feasible for your client to demolish the structures that are less than a foot from the property?
He'll have to get a building permit, so he would have to produce the drawings. Say that takes 2 weeks. Then you submit it to the building department, and it would go through the routine of sign-offs. Honestly, I'm not sure how long that would take. I would think maybe a couple months. Do you have any guidance that you could share?
It varies widely depending on the number of times it needs to be resubmitted, comments.
Addressing comments, going back. That's out of our control. That's in the hands of the county.
You don't legally have to have the building permit to do the demo, do you?
I would think you would.
Is that right?
I don't know that for sure, but I would think so.
You need it.
Well, usually the demo permit is part of the building permit.
I see.
You're going to need a permit to take down that wall.
So where I'm headed towards is you've offered a bonding,
Filed by a certain date.
right? And then, I think a year to demolish is too long, right?
Agreed.
And so I'm trying to figure out how to compel demolition faster. And I like the notion of a bond, and so I'm just trying to figure out what's a reasonable time and trigger for making sure that gets done as promptly as is reasonable.
I had suggested to my applicant 2,000. I think that might be an appropriate amount for the bond. I would think it could be accomplished within a year. I just don't know how long it would take to get the permit.
Well, maybe if I can ask, would you be comfortable, should there be an inclination to grant you some relief, to seek a permit
Within a month.
well, yeah, I was going to say, you said 2 weeks, but
We can file within a month. That's easy. We hire an architect, he submits the plans.
then that's and then it's out of your hands really in terms of when it's granted.
Yeah.
That would be, I think it would be unreasonable to, try to mandate when the county acts, but certainly I think it's reasonable to mandate.
You all can also have this come back in 6 months for a review, since you enjoy hearing it so often.
There is broad support for that.
Okay.
Ms. Malice?
So, Bernie, a building permit is good for 1 year?
Don't know. I would assume it is.
I'm trying to stack the time. So if there's a building permit issued in a month, that means in 13 months that building permit expires if no action is taken.
Well, then we would be in violation of the condition I would submit.
The condition being that
That he'll get a building permit
I'm saying-
and that he'll bring it in a foot if that's what you all decide to do.
yeah, it'll be back to where we are right now.
Well, he would get a zoning violation.
Zoning violation.
And you can, if there's a true health, safety, welfare concern, that can be enforced by injunction by the county attorney.
We could stipulate that if a building, that the applicant proceed forthwith after the issuance of a building permit.
Mm-hmm. If you want to pass this over, I could write up something and submit it to the staff.
I don't know, I'm pretty close.
Okay.
So, just a comment. I believe that if I'm one of the neighbors sort of had laid out our conversation regard to what it is we were requesting as far as the survey goes. And I believe that our interest in getting a complete survey was in part to assure those neighbors that there were no other areas out of conformance. And so I think just having done this small part of it, doesn't give them the assurance
Well-
that everything else is in order.
I hear what you're saying. The reason we didn't do the whole property is it would have probably been 8,000. It was about 2,000 to establish the one line. And then if you're doing all four, it's just an enormous amount of engineering work. I'm talking about a true boundary, not a house location.
Not a house,
Yeah.
boundaries. Because the house location, I think, would have satisfied some of
But
the
see, a house location is of no value, because all that does is it says that the improvements aren't encroaching onto the neighboring property. You can't use a house location to measure distance to boundary lines. It's just not meant for that. That's how so many people get in trouble and come before you.
It is used to measure setbacks.
Well, in all honesty, it probably shouldn't be
Instead,
a boundary.
a boundary.
Yeah.
Yeah, I mean,
That's, when I'm hired, first thing, I get a boundary.
staff does not require a boundary to perform its job. They just want locations and setbacks. Okay, thank you. The chair has stepped away and asked me to do the meeting. Does anybody else have anything they want to add right now? I think people are writing
I'm scribbling out a motion. Might take me a minute.
I don't have a sense of the board as to whether a motion will pass or not, even with additional writing. Does anybody want to help Peter write a motion, or tell him it's not necessary to go to that trouble?
There's not 3 votes. If there's 3 votes for denial, I'm happy to just stop.
Right, that's what I think we're talking about.
I had a question for Mr. Lawson. So you were saying with this the fire safety requirements. So you were saying that's not really necessary because the building permit contains that. So is this language based on the requirements for a building permit for fire safety?
That's my understanding. I went to Mike Stevens, who is very skilled at this type of improvements, and he said this is what would bring it into compliance with the fire code. So I just wanted to specify it, but if we have to get a building permit, they're going to make us do this anyway, I believe.
Okay, I gotcha. Okay, thank you.
Question I have for staff, given the proposal to move the setback to 1 foot, would that change your recommendation, or would you need time to evaluate that?
I think that we provided an alternative resolution that was actually slightly less than that, so I think that would be okay.
Just to give you guys an outline of what I'm writing up, my notion, and again, if there's 3 votes for denial, we don't have to go through this, but what I'm gleaning is applicant give a $2,000 bond by the end of this month. Applicant to apply for the building permit by July 20th. Building permit to be issued not within the typical 1 year, but within 6 months. Demolition within 14 days of receiving the building permit. And bond not returned unless all conditions are met and the final building inspection is conducted. So that's what I'm gleaning seems to be on offer from the applicant. And then, of course, the approval would be for a 1 foot setback to the eave, otherwise within the building envelope that was on the most recent application for the garage only. So substantively, it's what's on the latest plat for the garage location, but chop off 9/10 of a foot on the south side. Yep, with some modifications. I'd be curious, before I make a motion, I'd be curious what people's attitude is about that.
I'm very sympathetic with one of the issues raised tonight, which is truthfulness. And I think we've run into this in many cases where a lot of the issues with neighbors have much more to do with good or bad faith than the actual structure. I am inclined to support Mr. Owen's suggestion for bond and to allow it to proceed.
Mr. Owen, could you, could you repeat in your motion, what was the period of time that they have to apply for the building permit? Was it a month?
July 20th.
Okay. Thank you. Yeah, I'm inclined to support the motion of Mr. Owen. I think the conditions, we've considered, what I feel is we've reasonably considered everything that's been addressed, what the complaints have been, and within a reasonable structure for the homeowner. So I'd like to support it.
Ms. Malice?
Similar to Ms. Freshman, a 1-foot setback, if that had been the going-in position, probably wouldn't have, gotten you a denial from staff and probably wouldn't have started this conversation. But and probably would not have resulted in this list of conditions. The list of conditions indicate our uneasiness with how this might transpire, and my personal concern is that we could end up back where we are after this period of time has expired, with the notable exception of the bond. That changes the equation a little bit, so that there is some loss on the part of the applicant should they not take the steps that we have recommended. So, I think I'm going to support it too, because we have put these things in here, and I think a 1-foot setback is not unreasonable.
Thank you all very much. I have a question, and it's a mechanical question with respect to worst case scenario. Say there's a violation. Who's the bond paid to?
The county. The bond would be forfeited to the county.
Okay. Thank you. Okay. Any further discussion?
So I just would point out to the neighbors, I'm part of the reason that I'm considering this motion as opposed to an outright denial is because I think that it actually is more likely to result in faster demolition. Because if we deny outright, the applicant may have other avenues open to him and open to them that could drag this out even longer. And so by putting the applicant at risk of a forfeited bond and putting the variance conditions and accelerating that timetable faster than we would normally do, my sense is that actually creates better leverage for faster demolition than a flat-out denial would get, as counterintuitive as that may seem. And you can't ask Mr. Lawson anymore why that's the case, because he's working for the other side. But anyway, that's part of why I'm thinking about going this route as opposed to an outright denial, because I think it actually could result in faster demolition.
That's not being recorded, and the period for public comment has been closed.
And even if you wanted to ask about it, I wouldn't answer the question. Sorry. But I'm just explaining why, and in general terms, why I'm trying to make this motion.
Ms. Malice?
So the bond is forfeit at what point? At the
If any of the conditions of any of the number of conditions, if any condition is not followed, then there's a forfeit of the bond.
Because there is a sequence here. So if the first step happens when it's supposed to, we're okay. If the second step, I should say it, at each point there could be a failure in these steps. Typically, we don't get involved with finding out if things are in progress, because I don't know that we really can do anything about it if not. But I'd be interested to know how we progress. I mean, certainly the neighbors would want to know, how do we how do we kind of keep everybody informed?
We can ask Barnes to tell us.
I'll do that.
Yep. You would come up and you would keep us informed?
Sure.
Thank you, Ms. Freshman.
I will keep the neighbors informed as to our progress.
And the expectation would be that if that progress is not met, that the neighbors would take action to prompt
A forfeiture.
the forfeiture, and that would flow naturally. I don't lack faith in their diligence at all.
Nor do I.
And I want to say that the issue of alacrity, of good faith, forthrightness, is a very serious one, that when you sit up here and you see citizens come and listen to them make requests, we listen to every utterance. And this perspective is very interesting because you can almost sense the lack of honesty, and it's not lost on us ever. So, unfortunately, neighbors have to continue to live together. And it's not unfortunate, but it's unfortunate. It's unfortunate that that bad blood is often created in these instances, and there isn't a resolution. So the unfortunate thing is that we can't bring the people together. But I encourage you to be good neighbors, especially the individual who has to really rehabilitate his image with his neighbors. And I encourage you to do that. Ms. Freshman.
Barnes, could you clarify the status of the shed? And if it's, okay, well, do that
My
first.
understanding is that there is a building permit for a relocated shed, and I'll get a copy and we'll send it to the two neighbors.
Well, I guess it's been presented that the existing shed, which is a particular
That's gonna go
concern to
away.
the,
That'll
Okay.
be raised and removed.
okay. Would you have an objection to that being part of the action?
No, ma'am.
Thank you.
How soon?
You don't need a permit for that, do
I don't think we need a permit, 30 days.
Okay.
And I presume that if another one's coming, it's going to be well within every boundary.
you? It'll be by right.
I don't care if it's in the middle of the yard.
Yes, ma'am, and I'll get a copy of that and I'll forward it to the neighbors.
Thank you.
Any further questions of the applicant's representative? If not, the matter's with the board.
I think we're working on a motion.
I just got a condition added, so now I have to write that in.
So we're basically starting with the alternate condition.
So a question for staff is, what's the very, 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 very final step of this whole process? It's all built, it's done, and then is there a C of O? Is there a final building inspection?
So in most cases, to final the building permit out, there will be a wall check survey done to prove that the
By the
walls. Yes,
Applicant does a wall
That's
check.
provided.
yes.
But there's no,
Certificate of occupancy, there's no such thing issued for an outbuilding?
Nah, the house is already occupied, and the accessory building wouldn't have a separate.
and the wall check survey is even before construction is completed, right?
Sorry, there can be a final survey that shows the location of the finished walls. The wall check shows foundation walls. A final survey will show the location of the final walls.
And then I'm just wondering, how do we refer to the shed that's being demolished? What should we call it so that everyone knows what it is? Is there only one shed?
In the southeast corner.
Okay, ready for a motion, Mr. Chairman?
Mr. Owens.
Okay, unfortunately, I'm just going to try and plow through, and we'll see how we do. So, Mr. Chairman, I move, based on alternative proposed resolution number 1 in the staff report, approval with a 1-foot setback. So using the text starting on page 5 of the staff report as the base, I would amend, on the second line, instead of rear setback of 0.1 feet to the eaves, to say 1 foot to the eaves of an existing accessory building. Oh, so this is in case V-11338-17-UP-1. Then in the conditions, for condition number 1, on the second line, after the word footprint, say footprint for, quote, existing 1-story garage, end quote. So that's to make clear that the footprint we're talking about is the one on the survey that's called existing 1-story garage. So the neighbors were concerned about whether or not other buildings might somehow be included. Then condition number 4, change the date from June 20th, 2019 to December 20th, 2019.
Okay, that's when they obtain.
Right, that's right. And then a mess of new conditions. New condition 5, that the applicant will give a bond of $2,000 by June 30th, 2018. That condition number 6, that the applicant will submit a building permit application no later than July 20th, 2018. Condition number 7, that the applicant will demolish the existing shed next to the garage no later than July 20th, 2018.
Sorry, what was that date again?
July 20th, 2018. Condition number 8, that the building permit, well, I'm sorry, that's covered by condition number 5. So condition number 8 would be demolition of all structures within 1 foot of the rear property line will occur within 14 days of the issuance of the building permit. And then condition number 9 is bond not to be returned without compliance with all conditions in the variance. No sooner than submission of final building wall survey.
Conditions of the use permit.
Of the use permit, sorry. That's my motion.
Is there a second? Thank you. It's been moved by Mr. Owen and with conditions and seconded by Ms. Freshman.
Mr. Chairman?
Ms. Malice?
The alternate proposal has a title, and in that it says approval with 0.9-foot setback. I think the title needs to be changed.
Yes, I would ask unanimous consent to change the title to 1-foot setback.
So moved.
Just no objection. No objection.
I just asked the applicants, if it's okay, Mr. Chairman, to ask the applicant's representative if they understand the motion and if they have any concerns about being able to comply with it.
We understand and will comply.
Thank you.
Thank you very much.
And I would just ask staff, do you understand the motion and can you enforce it?
We understand the motion and will enforce it.
Okay.
Thank you very much, Mr. Risky. Any further discussion?
Hearing none. All in favor of the motion as described in case V-11338-17-UP1 signify by saying aye.
Aye.
All opposed? The ayes have it, and the matter as amended has been approved. Thank you all very much. Mr. Reese, we'll let the room clear for just a moment. And then proceed to call the next case.
Case number V-11358-18-UP-1 is a use permit request by Gang K. Nugent and Tam T. Doe, the owners, to permit a setback of 11 feet to the wall, 9.8 feet to the eave of an addition from the South Fillmore Street right-of-way instead of 25 feet to the wall, 21 feet to the eave as required, and to permit a setback of 6 feet to the wall of an addition and new porch instead of 8 feet to the wall and porch as required from the side property line, and to permit an aggregate side setback of 17 feet instead of 18 feet as required regarding a new front porch and 2.5-story addition on a corner lot in the R6 zoning district, premise known as 2900 2nd Street South. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Any questions of staff?
Mr. Owen?
In the county arborist's statement and the staff report,
This one does not have an arborist report.
sorry. Which one are we on then?
This is on Second Street. The next one is.
Oh, okay. Got it. My mistake, sorry.
No, the agenda
Got it.
Yeah,
I'm sorry. I have no questions on
it
this
was
one.
out of order in the packet.
No
The
questions.
agenda, yeah.
I had to switch mine too. No questions? Any other questions of? Okay. Jiang K. Nguyen and/or Tam T. Doe?
Mr. Doe, how are you?
Some win.
Oh, I'm sorry, Mr. Nguyen.
Yes.
How are you?
Hi, how are you?
Very well. Anything to add?
No, sir.
Thank you very much.
Last time, 2 months ago.
Ms. Freshman?
I'm just noting that our concern was neighbor feedback, and there's a considerable amount of it.
Mr. Chairman,
Mr. Owen?
I would just note that on my recent walkthrough, I noticed that there's very prominent houses on other nearby corners in this neighborhood. So, for example, at 6th and Walter Reed, there's another very prominent corner house. So I think that this appears to be in conformity with traditions for this particular neighborhood.
Thank you very much.
Speakers?
We have no speakers signed up?
Motion?
Ms. Freshman, I'd be happy to entertain a motion.
I move the Board of Zoning Appeals adopt the attached resolution approving use permit V-11358-18-UP1, subject to conditions listed in the proposed resolution.
Thank you. It's been moved by Ms. Freshman and seconded by Ms. Malice to approve the requested use permit. Any further discussion? Hearing none, all in favor of granting V-11358-18-UP1 signify by saying aye.
Aye.
All opposed? The ayes have it. The matter is granted. Thank you very much. Thank you for coming back with this outreach.
Thank you.
Thank you.
Please call the next case.
Case number V-11331-17-UP1 is a use permit request by Sylvester Golja and Elda Golja, owners, to allow a setback of 5 feet to the wall of a detached accessory building, 4 feet to the eaves instead of 25 feet to the wall, 21 feet to the eaves, from both the Arlington Boulevard right-of-way and the North Fillmore Street right-of-way, and to permit a structure between 3 feet and 10 feet high within the triangle for vision clearance at the corner of the lot, regarding a new one-story detached accessory building on a lot with 3 right-of-way frontages in the R6 zoning district, premise known as 1 North Fenwick Street. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. 2 additional proposed resolutions have been provided if the BZA should decide to approve the request. And please note there is supplemental material for this case. That is the arborist report and an email from county staff regarding the arborist report.
Mr. Chairman.
Thank you very much. Mr. Owen.
In that email that you just referenced, the county arborist says, I reviewed the report and need more information from the consulting arborist in order to determine if the trees will be adequately protected. A landscape plan should be provided to us that shows the locations of the trees, their critical root zones, and tree protection measures in relation to the proposed structure and construction. So my question is, has such a landscape plan been provided to the county arborist? If so, what is the county arborist assessment based on that needed information?
As far as this staff knows, a landscape plan has not been provided only because the arborist report is what the board at the last hearing requested that the applicant provide.
Okay.
So would it be, let me ask Mr. Reese, were we inarticulate in our request?
I can't say for certain. I think that we all assumed that this report would cover best practices on how to preserve those trees, and I think in some ways it did. I think that when we shared it with the county's arborists, they had a desire for more information than was provided in here, which I don't think anyone could have foreseen at the last hearing.
To have asked the arborist first, what should we ask the applicant to provide? We might have been backward, really, and presumptuous. So I would ask the board, are we, well, how does this, what was provided, because the applicant obviously went to some expense and trouble to accomplish our request, and it looks as if they did just that. How does our lack of assuredness on the part of the county's arborists, does it hinder us? Does it?
Mr. Chairman?
Mr. Owen.
So under the zoning ordinance, the conditions for granting a use permit require that we find that significant trees and foliage will not be damaged. And it's the applicant's burden to show that. And I think what we identified in the last meeting that we had on this was a lack of clarity to us. We said, essentially, the applicant, you have not demonstrated that the trees are safe. In this case, we have extremely significant trees that are, they're large trees, they're publicly owned trees, they're off the property. And so, I appreciate that we were, trying to provide some clues as to how that might be established, but it's still not established. And ultimately, I think it's the applicant's responsibility to establish it. And we're holding a hearing tonight, so perhaps more information will come to us right now that will assure us that those trees are not damaged, but are not at risk. But if there isn't enough evidence, then we'll have to take that into consideration when we apply the criteria.
And let me ask, just to be clear, these trees are in the right-of-way.
These are not the applicant's trees.
I think there's a mixture.
Okay, I'm just thinking of the,
Let's see, there's a tree, I think the white oak.
The white oak is the big
that's
one.
splitting,
It's cleaved, that the arborist recommends be cabled. If that tree is on the right-of-way,
So,
correct?
And it's,
I think they're thinking of the one that's
On the front of the report, that you can see the cleave, and that it's,
so
things like English ivy, I can imagine they would do. I'm wondering what the ability is of the applicant to affect changes on trees on property that they don't own.
I think,
Mr.
I mean,
Chairman?
I'm noting throughout, it says on this report, the tree is owned by Arlington County, and it says in multiple places, the tree owner should, the tree owner should, the tree owner should. So that isn't the applicant's issue.
Well, here's my question.
I mean, Ms. Moss, I'm sorry.
So, I'm reading the report, and in the first paragraph, where it's sort of the instruction to the arborist, is you indicated you wanted to understand the impact that construction of the garage would have on the trees owned by Arlington County. The report doesn't seem to answer that question.
I think that's my core point. If you look at the arborist report,
And that's perhaps why Mr. Reese forwarded it to our internal arborist, because we didn't ask him to consult our internal arborist.
yeah, we did.
Our
Yeah, we did.
the Arlington arborist. We asked the Arlington. So, I'm sorry, but it doesn't look like this report answers the question that the applicant asked them to find on. Because it says, please understand the impact of constructing the garage would have on the trees owned by Arlington County. And this report does not answer that question.
Mr. Chairman, I would just,
Mr. Owen.
yes, so I just point out that on page 3 of the private arborist's report is a photograph that has 2 red lines on it. It says, red line indicates approximate garage corner closest to white oak tree, right? And really, to me, that's the critical question is that too close to the white oak tree? And I was hoping that both arborists would opine on that, and neither did. And so we got super close to the one thing that mattered. I wasn't really concerned about the English ivy and the cabling. You know, we're here to approve a garage location, and my question is, does the garage location affect significant trees or foliage? And I didn't learn the answer to that through this exercise.
Well, I can appreciate that. One thing I learned was that the tree may not be significant if it's this damaged. A diseased, damaged tree has less significance than a healthy one that is not in need of repair to preserve it. And to a limited degree, I mean, this from my point of view, this opinion is not as definitive as I think we would like. But there is some reference, like the second bullet under recommendations. It's to limit soil disturbance or further soil compacting in the area of the new garage, or its overdig in the area of the Arlington Boulevard Trail. And then,
Chairman,
Go ahead, Mr. Owen.
respectfully, I would just suggest that we proceed with the item, hear from the applicant. The applicant may want to address this issue, and then we'll all have our, and there's other factors. I mean, staff has recommended denial here for completely different reasons.
Yeah.
So I think maybe it would be more efficient just to move forward and digest it.
Let's do just that.
thank you very much. With our discussion, any further questions of staff at all? Hearing none. Ms. Applicant is before us. Let me get your name in front of me. Godola?
Yeah.
Welcome.
Good evening.
So, the floor is yours.
Yeah, following last meeting discussion, I submitted that, I contacted the arborist. I submitted the report, and verbally he told me I don't see any problem for you to build the garage. So he prepared the report, I submitted to the county, and I gave the arborist information if they have any more questions, because I don't know how to respond this question. Is the professional arborist to respond, and so I'm hoping that you approve one of the alternative proposed resolution from county. I'm okay with either of one.
Any questions of Ms. Godola?
Have you seen this email from the county arborist?
Yeah, I saw today.
But did you receive it before today? Did Mr. Rissy forward it to you?
I received, Mr. Steve forwarded to me 1 week ago, and I was checking today all the report before I come here.
Mm-hmm.
I saw that email, but I don't know it was for me to answer that, because it needs specialists to answer that.
Okay.
Yeah.
So you didn't forward it on to your arborist for a response?
No, it was today.
Okay.
Maybe.
Understood.
Thank you.
Thank you.
Any other questions?
Well, just for staff, I mean, what happened when you got the email on the 5th? Did you forward, you believe that you forwarded it on to anyone, or you just put it in the file?
Not immediately. I talked to the applicant, during the process, but it wasn't, the day or maybe even the week that I got the email from the county.
Okay, thank you.
I still saw them fulfilling,
Mr. Owen.
So staff's concern is you think it's the garage is proposed to be built too close to Fillmore Street, is that right?
Correct.
Okay. But if it were 6.5 feet back, then it would be acceptable. Can I ask the applicant a question, Mr. Chairman?
Yes, please.
So if we move the staff's recommended alternative of 6.5 feet back from Fillmore Street, would your garage then be smaller, or would you move it west altogether?
I'm okay, even if it will be smaller, I'm okay with it. I just wanted that size because to fit two-car garage. If it will be a little bit smaller, it will be just for one car.
Okay.
And
Mr. Chairman, I think, go ahead.
I mean, but I don't think she may not have understood the question in terms of how you want.
We're suggesting, well, how staff suggests it could be moved.
if I move on west, will be closer to the tree.
Yeah, that's what I'm concerned about, exactly.
Yes, because there are my tree, and then behind my tree is the county trees. But I think 5 feet will be okay from Fillmore, but it's up to the county how they decide.
So what's the proposed east-west width of the garage as proposed? 22 feet by 22 feet.
Yep.
So, I mean, basically what I'm thinking is that it would be 20 and a half feet wide instead of 22 feet wide. And then it would be 6.5 feet from Fillmore, but not any closer to the tree. Right? That's what my understanding is that's on the table.
Okay.
Is that what your understanding is as well? Applicant's nodding her head, and staff, is that consistent with your understanding of what alternative proposed resolution 1 would do?
I think that there are options either way for it to be shifted or reduced.
Okay.
You can clarify that.
Miss Freshman?
I'm just saying the whole thing could move so that you'd still have two-car garage, or is there a problem with the diagonal measurement to the house?
You're taking 1.5 feet off?
No,
Setting it back, not necessarily taking it off.
right, that was the first idea.
That impacts the trees. So making it
Well, that's further away from
No,
the
it's
tree.
coming into her property.
back that way.
No, isn't the tree here? That's my concern.
So
Maybe the tree is here, but I thought it was here.
So it does have to be smaller.
Half is 21 and a half, that's 10, 20 is 2 car lanes.
My garage is 18 feet internal. Yep.
You know, 21 seems like it would work.
Okay.
Yours is a little small, 19, I think is what they recommend as a minimum for 2-car garages. Yours is in a townhouse?
Yes.
Yeah.
Okay.
Any further discussion? Anything else you want to add, Ms. Godola?
So you heard our discussion about the alternative.
Yeah.
Okay.
Matters with the board.
Mr. Chairman,
Mr. Owen?
In matter V-11331-17-UP-1, I move alternative proposed resolution 1 with an amendment to condition number 1, adding a new sentence at the end, west wall of garage to be no further west than depicted on the attached plan, or the plan than depicted on the plan in the staff report.
Second.
Any further discussion?
If I say plan in the staff report, do you know exactly what that means? I'm asking staff. You're holding up. What are you holding up?
I'm holding the proposed site plan.
Okay. So we're all in agreement as to what's being referred to? Yep. All right.
No further discussion?
All in favor of the, Mr. Owens' motion?
The alternative resolution in V-11331-17-UP1 with the additional condition as seconded by Ms. Freshman. All in favor signify by saying aye.
Aye.
All opposed? The ayes have it and the matter is granted.
Thank you.
Thank you. Good luck.
Good night. Thanks.
Thank you for being agreeable.
Yeah.
Please call the next case.
Case number V-11366-18-VA-1 is a variance request by Stephen Resnick, contract owner, to permit the construction of a new single-family dwelling on a lot that has a width of 48 feet instead of 50 feet as required in the R27 zoning district, regarding a new single-family home and rear deck in the R27 zoning district, premise known as 1957 South Kenmore Street. Staff recommends that the board adopt the attached proposed resolution granting the variance request with conditions.
Thank you very much. Any questions of staff?
I have one.
Ms. Malice?
A water line plan, that was, I read in the report that the Knock community was looking for the applicant to take care of a water line.
I believe that may be addressed with the final exhibit in the application package, which is the agreement between Stephen Resnick and Brian Hill.
Can that be made part of, is that a private agreement?
It's not a condition, though.
It's not a condition. Could be a condition to include that.
I think that's up to the board.
It's interesting. It says this agreement is conditioned on obtaining a variance from the Arlington BZA. So it's I will if you will. I will if you will.
But it's not signed or dated, so.
Well, it follows our action. If we grant, they'll agree. I mean, looks like.
But if they don't agree, then we don't grant.
Right. I believe Mr. Hill is here also. Okay, let's, because I have a speaker slip from him. He's indicated support. So, any further questions? Okay, let's hear from the applicant. Welcome back, Mr. Resnick.
Thank you, Mr. Chairman, members of the board. I can give you a summary of what I've done in terms of outreach since the last time, or I can just jump to the finale.
I'd like a little summary, because that was a big part of the last, and I'd love to hear the friends made.
I realize that, and as I said before, this was the first time I've had to do neighborhood outreach. I didn't realize the extent of what I was expected to do, and I do apologize to everybody involved for not having done that up front. To give you the summary, basically after the meeting back in April, I met with Portia Clark, Mr. Hill, and the other neighbor outside in the hallway. We addressed their concerns, or I addressed their concerns verbally. I think we basically resolved everything except for the width of the house and the side setbacks. Portia asked me to provide that in writing. I sent her emails. She asked for elevation showing the three houses. I had my surveyor do that, presented that. I went to the meeting, the Knock meeting in May, where again, the primary concern was the side setbacks. There was also the issue about the water line, and even though I was saying, look, I told the BZA that I would do it, I'm telling the Knock Association I would do it, they asked that I put it in writing, and therefore they continue, instead of voting in the May meeting, they continued it to the June meeting. In the interim, after that meeting, I went home and realized I had another plan, another house that I had built several years ago in the city of Falls Church that was approximately the same amount of square footage, but it was 3.5 feet narrower. It was just much deeper, and I gave up the front porch. So it basically provided an extra 2.5 feet of setback on Mr. Hill's side, or 2 feet, I'm sorry, on his side, and 1.5 feet on the other neighbor's side. So I sent that to Portia, presented that at the Neighborhood Association meeting just a week ago Monday, and the vote was, nobody voted against it. There were 2 or 3 people who voted not to take any opinion, but the vast majority voted to, approve or the application. So that's basically where I'm at. It's a different version of the house, but as last time, it complies with every other zoning requirement in terms of setbacks, lot coverage, heights, everything else.
Very good. Thank you very much. Any questions of the applicant? Hearing none, don't go far, Mr. Resnick. Let's hear first from Radia Sarah. You're going to have to help me at 1959 South Kenmore. Siri.
He's coming.
I see. Yes. Welcome.
Good evening.
1959 South Kenmore. Welcome. She's bringing it down.
Thank you.
He's gonna help you take it down all the way. It'll go down even lower.
Good evening.
Thank you. Welcome.
I
indicate undecided. You're kind of in between.
yeah, I got
Slip.
the
Can I help you?
You may, and who are you?
Brother, I live at, my name is Sonorin Kurtnet. I live at 2011 South Kenmore Street.
Okay.
I am her brother.
Okay, her brother. Fine. Welcome.
One question she had. She wants to know the house, the one that going to build is one side it gets 12 feet, and on her side get 5.5 feet.
9.
9.5 feet. She wants to know why she don't get the same size.
That's a good question. I'm going to ask Mr. Rissy to explain what the setbacks can be on the sides and how it's an addition. It doesn't have to be equal on either side. One side can be heavier than the other, but if you would.
Standard setbacks for residential lots are 10 feet for both sides. One of those 2 sides can be reduced down to 8 feet, and then there needs to be an aggregate as well, which can be at least 18 feet and can grow depending on the minimum lot size of some of the larger zoning districts.
Okay,
Ms. Malice.
so, but is the question why the building placement, why it's not being placed equidistant? Is the question why is it not the same on both sides?
Yes.
Yeah.
That's for the builder.
And we will hear from them.
We'll ask the builder that. Any other questions?
That's it.
Just that one. Thank you.
Wait, I do want to follow up on this question with staff. What is staff's understanding of the right side setback that's proposed?
The right side setback to the building is 9.5 feet. To the building eaves is 8.5 feet. To the planters is 6.5 feet. To the air conditioning units is 8.3 feet. To the
To the
entry
planters, it
porch
was
is
what?
9.5. To the planters, it looks like 6.5.
So why don't the planters have to be 8 feet away from the property line?
There are a number of different building elements, including stormwater planters, which are granted a allowance to encroach a certain amount. In this case, 4 feet off of the required.
Okay. So I guess, I'm sorry, where did the speaker go? So just there's different distances to different parts of the house. And the law says that all of, what you just heard, I hope, was that the law says that all of the building has to be at least 8 feet from your property line or from your sister's property line, except stormwater planters. So the stormwater planters are 6.5 feet, but the rest of the building is 2 feet farther away. So that's part of the answer to your question. And the main building is not all 6 feet away. Most of it is at least 8 or 9 feet away. But I understand that's not all of your question. Ms. Malice had the rest of your question, which is why isn't it in the middle? And we'll ask the applicant that question as well.
Thank you. That's a county qualified is at least 10 feet, right?
No.
No?
It was.
So one side can be reduced to 8 to the building wall.
Then the sum, the aggregate, has to be 18.
One side plus the other side have to add to 18.
Thank
So it
you.
can be 10 and 8. It could be,
Or it could be right in the middle.
it could be 9 and 9.
But in order, right?
It's, right now, it's not 9 and 9.
Right.
We'll find out why not.
One can be reduced to 8. It doesn't have to be reduced to 8.
And we do, but we have some more speakers before we get back to the applicant. Let's go with, that was the undecided. Then we have,
And that's the answer to the question.
This one hasn't indicated
They can't.
whether they're
for
One would need to be 10, yes.
2020, Mohammed Alam. You have, it says, please check if for or against. So you didn't really indicate. Please, we'll hear from you right now, though, regardless. Mohammed Alam of 2020 South Glebe Road.
Yes, sir. Thank you, Mr. Chairman and respected member. I'm here just to tell you a simple truth. Me and my wife, we bought the house 2020 South Glebe Road in February 2005. Since then, behind our backyard, our neighbor has their own fence. We have our own fence. And I have been seeing that last 13 years. So it does not make any sense to me, since it was not an issue for last 13 years, why it is an issue now. So I'm confused, really.
Why is what an issue?
Just to say that the fence is not in the right place. It is in the right place last 13 years.
Your fence is not in the right place?
No, the other owner fence.
Why does that bother you?
behind you.
No, it said last 13 years, it was the owner constructed their fence. And we did not have any dispute last 13 years. So we have a new issue. I don't understand this. I'm actually a layman.
Who has talked to you about the fence being in the wrong place?
No, the letter we received, that's, yeah.
Let's see what you have there. Okay.
Okay, this is just the notice that
that your neighbor, Mr. Resnick, wants to build a house, and this is simply giving you notice of tonight's meeting. It really doesn't do anything with respect to your fence. You know, that vacant lot that's behind you. He wants to build a house in that lot. And so what we've been discussing really with other neighbors is how close he can be and how wide the house can be and other issues with respect. There's a pipe that runs underneath, but it really doesn't have anything to do with a fence for you at all. Actually, there's
Mr.
other
Chairman.
property in between you and the, you're in a townhouse there. There's other property between you that's kind of it looks like it's county-owned. I think we asked about that.
Says it's an alley.
An alley, yeah.
So, I'm sorry, we should probably ask the applicant to use the microphone.
If you
Yeah,
can talk to the
behind the podium.
microphone, everybody can hear you.
I'm here because since I received the notice, I think I should be physically present here. And I do apologize, I'm sorry, we are not able to come to this meeting last time because of, some family engagement. But the people come from overseas to visit us, and we...
Well, let me ask you this just directly. Do you object to Mr. Resnick building a house in this vacant lot?
No, I'm not objecting that. What I am objecting, if there is anything done with the fence.
Okay.
Yes, sir.
Mr. Chairman, I just wonder if Mr. Resnick is aware of any problems with
We're
any
going to have him. We're
any
going to
fence.
hear from him in just a
Yeah.
moment.
And you're going to be given back your notice. Thank you for coming.
Thank you, thank you.
Notices work. At least this time.
Are there any more speakers?
Yes, we have one more speaker. Mr. Hill, Brian Hill, 1955 South Kenmore.
Welcome.
Thank you for coming back.
Thank you for having me.
Would you raise up the podium, that button on the right, on your right?
I don't have my glasses on. When I see an arrow, so I'm going to push the up arrow. Okay.
Up arrow
That's
should
it.
do it.
There you go.
Thank you.
You're welcome, sir. In the interim from the last meeting till now, Mr. Resnick shared is pretty much kind of how things went. He did some of the issues that I know that I brought to his attention was, I wouldn't have an issue at all if you would have just built a narrower house. So he did come back with a narrower house. We talked about the setbacks, and they were larger. He did share with me upon moving the water line that he would cement over where the line is dug to the sidewalk where I enter my house. So it's not inconveniencing me at all because I do enter my house from that side of the property where you see there's a sidewalk in front of the house that just ends. So he's going to, move the water line to that, dig it up, put the sidewalk there for me. He's building a house that's narrow with a driveway. With a garage, which is not having an adverse effect on parking because parking is kind of bad. And so as it relates to the setbacks, he, is meeting the requirement. I know myself, I wasn't in opposition of, obviously my kids run around and blow bubbles on the grass, obviously. So, okay, but I know I can't necessarily control who buys a house and who puts it there, whatever, just accommodate me to the extent of the law that I'm requesting. And so, once we got to talking, he did jump through the appropriate hoops. He did come back humble and said, I need, this is what I'm presenting. And so I, at that point, I know, and I could not do anything further to prevent him from building the house because I didn't really want to prevent. I just wanted to make sure my rights are respected. And they have been. He said he would, in addition to digging a line up, he would lay the cement down, connect the cement to the sidewalk so I could walk in my yard without having to wear a path in the grass. So I don't have an issue at this point. I like it as it is, meaning the 12 and whatever the 9.5 on the other side. And I'm not unhappy with what his amended plans. Thank you.
Thank you. One question I know that we have.
Yes, sir.
agreement between Stephen Resnick and Brian Hill that we have in front of us as a part of the packet.
This is going to be freely entered into by you?
Yeah, I ended up, I'm a teacher, just my last day of work was yesterday. I'm cleaning my classroom, forgot to print it and sign it. He came by, said, man, I didn't sign that thing again. I said, I'll just come to the meeting and share with them that I'm, in agreement to what you said you were going to do in writing. I can sign it right now if you need me to do so. I don't have an issue with that.
I think it's to your interest to have it signed.
Yes,
since
ma'am.
it
Yes,
benefits
ma'am.
you.
No worries. No worries. I can do that. Do you need me to sign your copy?
No, I think you each should have a copy of a signed document. It's a private agreement. It's not with us.
Yes,
We
sir.
will, certainly, a signed copy can be provided and added to the file.
Yes, sir.
I take the statement that you're going to sign it, you're entering into it. Mr. Resnick obviously proposed it to you, that it's going to be executed. So we wanted to make sure that it was freely entered into by you and Mr. Resnick.
Yes, I totally understand that, and it was, and I will meet with Mr. Resnick, and we can sign the form, and we'll print a copy out, so I have a copy as a copy. And
I'm ready to make a motion.
Anything else? Any other questions of this applicant?
I do.
Mr. Owens.
I have questions for the applicant.
Yeah.
So if we could ask
Thank you,
Mr.
Mr.
Resnick some
Hill.
questions.
Mr. Resnick?
Yes.
Could you address that one?
Question with respect to why you
Cited it where you did.
Sure. Well, actually, I think there were three issues, and if I could address all three. One is the water agreement.
Okay.
I had the agreement on my computer, was prepared to print it out and bring it to the meeting last week. Unfortunately, my printer was broken, so I actually hand wrote the agreement, and I signed it, brought it to the NOC meeting, gave the original to Ms. Clark. So that was just signed by me, and actually I forwarded a copy. I took a picture of it with my phone. I emailed it to Mr. Reese at the start of the meeting a couple hours ago. At the meeting, can't remember if it was Mr. Hill or someone said they wanted it to be a little more formal. They would prefer to have it printed on a computer. My printer is still down, so what I did was I emailed it to Mr. Hill last Wednesday, and I hadn't heard from him. I think it was by Sunday I went over. He said he would have it Monday, and it's just been several days. So basically, we have agreed, yes, I'm going to do it. I still don't exactly understand why he needs to sign it. The onus, I'm the one who's saying I'm taking the responsibility. And obviously, the reason I put in, as you said up front, you were questioning, well, it was sort of that catch-22. That was simply so that if, for some reason, the board turned me down tonight, the only reason I'm moving the water line is if I'm building the house. That's the only reason that language was included. As far as the fencing, the neighbor on Glebe, I don't understand how the fencing, there'd be any impact. Simply because there's an alley. So the fence at the back of my property is not the same as the fence at the back of his property. They're separated by 10, 12, whatever feet. There is some question I've discussed with the 1959 neighbors. There's a chain link fence that runs down the side. I wasn't quite sure who that belonged to. They said it's theirs. And I've told them, I said, look, I'm going to put a wood fence there. At my expense, if they want, I will remove the old kind of rundown chain link and put up a wood fence. If they want to keep the chain link, I'm still going to put a wood fence. So that's as far as the fencing. As far as the setbacks and why the house is positioned the way it is, the reason is there's actually more distance between my house and the 1959 neighbors than there is between my house and Mr. Hill. If you recall, Mr. Hill's house was built over the property line and is actually only 4 feet from the property line. I have an additional 12 feet to my house, so there's 16 feet of total setback between our two houses. On the other side, there's now 9.5 feet between my house and the property line and 8 feet to the 1959 neighbors, so they actually have 16.5 feet. That's why it was done that way.
Anything else?
Any other questions of the applicant? If not, Ms. Freshman, the matter is with the board.
I move the Board of Zoning Appeals adopt the attached proposed resolution approving variance V-11366-18-VA1.
Is there a second?
Mr. Chairman?
I'm going to give that to Mr. Melnick and Mr. Owen.
Yeah,
for
just
discussion.
since Mr. Resnick was facing us, I want to make sure that the other speakers who came all the way tonight understood exactly what the answers to their questions were. So why is the house 8 feet from one side and 12 feet from the other? The reason is from the property lines, it's 8 and 12, but Mr. Resnick noted that the actual houses are your house from your property line and Mr. Hill's house from his property line are not the same as each other. So the actual distance house to house is supposed to be the same, but the distance to the property lines are different. So I think that's the main answer to your question. And then with regard, who had the question about the fence? And so the issue with the fence is, I guess Mr. Resnick intends to build a wooden fence where there's now a chain link fence, and he's just going to do it. And I guess that might involve replacing a chain link fence that's there now. And I'm not sure, is that right? Am I correctly understanding this?
His fence is,
Yes, I intend to either remove.
Where is the fence that we're talking about, the chain link fence?
Well, there's a chain link fence at the back of my property. Then there's an alley where the storm sewer is.
Right.
Then I believe there's the speaker's fence.
Right.
So the fence that I'm building, whether I remove the chain link or whether I simply build the wood fence in front of it, has no impact on his fence. His fence will not be touched at all.
The fence on his side.
Right, because we're separated by the alley.
There is a fence.
I believe
that
there
he
is.
looks out the back of his house that's on your property.
No.
No.
There's a fence at the back of his property, a chain link fence. Then there is an alley that is whatever it is, 10, 12, however many feet wide.
Whose property is the alley?
It's county property.
Okay.
Then there is a second chain link fence at the back of my property.
Right.
All I'm saying is I am either going to remove my chain link and build a wood fence, or I'm going to build a wood fence in front of my chain link.
Right.
But
So
either way, it will have no impact on his chain link.
2 chain link fences.
At the back, yes.
The one nearest his house, no changes. The one nearest your house, you're going to build a wood fence there, and maybe you'll take down the chain link fence and maybe you won't.
Correct.
Okay. So that's the answer to your question.
But no impact on
The rear neighbor at all.
correct. Anything else in discussion? Hearing none. All in favor of the motion in V-1136618-VA1 to approve the variance signify by saying aye.
Aye.
All opposed? The ayes have it. Thank you very much, Mr. Resnick, and thank you to the neighbors and the Knox Civic
really
Association.
appreciate your taking the extra time to go through the process.
I appreciate your letting me have that opportunity, and I know going forward exactly what I would need to do if I have the same situation. Thank you.
And, Mr. Rissy, if you would please call the next case.
Case number V-11372-18-UP-1 is a use permit request by Patrick Jansen, the owner, to permit a setback of 2 feet to the wall of a dwelling, 0 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required from the North Pershing Drive public right-of-way, and to permit a setback of 15.5 feet to the wall of an accessory building, 15.2 feet to the eaves instead of 25 feet to the wall, 21 feet to the eaves as required from the North Pershing Drive right-of-way, and to permit a setback of 2.8 feet to the eave of an accessory building instead of 10 feet as required from the rear property line, and to permit a setback of 12.4 feet to the building eave instead of 21 feet as required from the North Cleveland Street right-of-way, and to permit a setback of 12 feet to the porch, 10.5 feet to the porch eaves instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from the North Cleveland Street right-of-way, and to permit a setback of 11 feet to the porch, 9 19.5 feet to the porch eaves instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from the North Pershing Drive right-of-way, and permitted an aggregate setback of 10.6 feet instead of 18 feet as required regarding the expansion of a garage, eaves on second-story addition over existing walls, and a new front porch in the R5 zoning district, premise known as 427 North Cleveland. Staff recommends that the board adopt, Staff recommends that the board adopt the attached resolution denying the use permit request. An alternative proposed resolution has been provided should the board decide to approve the subject use permit request as advertised.
Thank you very much. That was a mouthful. Any questions of?
Oh, sorry, before I go on, I do want to mention that there is supplemental material for this case that came in after the application packet was assembled and printed. It is a plat in front of you submitted by the applicant today that I think he can speak to.
Sure. Ms. Mel?
This is not what was advertised, or?
It has some very minor modifications to the rounding of corners. I do not think this in any way is an addition to what was advertised, so I think that what is shown here can be approved in lieu of what was advertised and as part of your staff packet or the application package.
Thank you. Any further questions?
Chairman?
Mr. Owen?
The staff agree that the proposed setbacks from Cleveland Street, considered alone and not considering any of the other proposed elements of the use permit application, meet the criteria for a use permit?
I think that we have plenty of examples of setbacks that are equal to or less than the proposed setback along Cleveland Street, so we would not have any issues with that.
Okay. If the BZA were to grant the use permit for the garage expansion, would the applicant need to obtain additional approvals for an expanded curb cut?
So, not the supplemental, but there is a plat that shows that the curb cut would be slightly expanded, and yes, the applicant would need to get approval from DES for any curb cut expansion.
Okay. Those are my questions for now.
Thank you. Okay. Mr. Jansen, welcome back.
Thank you, members of the board. So we went back and so in question, the real question that we had last time was the part that extends out towards Pershing, which is right on the easement. So our suggestion would be to go ahead and go back 2 feet, take that down, properly secure the basement because it actually goes right down to the basement. So we would go ahead and secure that so we have room between the easement, sidewalk, and the house itself. And then as the new survey shows, the only real modification between this survey and the old survey is the bottom left-hand corner. Since we're losing a little bit of room, there's like a little indentation where there's some stairs in the initial survey. Basically, I just want to go ahead and just square that off, which it really doesn't do much.
Mr. Chairman, I don't understand what's being referred to. Oh, now I do. Now I see it, because it relates to one of the questions I had.
Back left.
So, in the northeast corner of the house, the previous plan had a sort of a sawtooth where the stairs come up to the back of the house. And now there's no more sawtooth. You're proposing a rectangle shape for the back of the house.
Yes.
Instead of a sawtooth.
Yeah, and that just, from configuring the inside of the house, that just makes a little bit more sense. It's literally like 6 feet by 6 feet or something like that, but it gives us a little bit more extra working space in the back.
So, if the applicant is finished, I have a slew of questions. So,
Do you have a question for the applicant? Or?
I think they're going to wind up being joint questions. They're sort of factual questions. So, so with the applicant's revised application, what's the distance between this new northeast corner of the house that's no longer a sawtooth and the easement?
All right, let me say that it isn't expressly shown on this plat, but on the old plat, the distance to that sawtooth corner was shown as 14.6 feet, adjacent to the 6.5-foot easement for street purposes, coming out to approximately 8.1 feet from the street right-of-way. Now, the lot line does narrow a little bit as it goes back, so in the current configuration, it is going to be slightly reduced from that 8.1.
Yeah, so that's my concern, is that I think you had identified that you couldn't find any examples that were closer than 6.5 feet to the right-of-way. And so if that's more than 6.5 feet from the right-of-way in that corner, then that would be more than at least one other example. But if it were less than 6.5 feet, then this corner would become, aside from the bump out, would be the record-breaking closest in the neighborhood.
It's actually 9 feet.
9 feet?
Yes.
All right, so this is good.
Yeah,
Good
for
that
my
you-
architect, that's a question I asked him right before the meeting.
Okay, well, that's helpful to know. Okay, then I'm just totally unclear about whether or not you're proposing any overhang of the right-of-way at the roof of the bump out after construction on the second story.
On the second story, if we're pushing it back, the overhang will be 18 inches. So we're still back, we're still 6 inches back from the easement.
So you're proposing 2 feet to the wall and 6 inches to the eave from the south edge of the easement for the bump out area. Is that right?
Well, okay, can you ask that question again? Sorry.
Yes, my question is what you're asking for to be 2 feet away for your wall of the bump out to now be 2 feet away from the easement, and for the eave of the bump out to be 6 inches away from the easement?
Yes.
Okay. I don't feel that's reflected very clearly in the staff report, but we can clean that up when we make the motion.
Okay.
Is staff's understanding as well of what the current application is for?
I think that staff had probably some of the same confusions that the board did. There were some slight discrepancies between the provided site plan and the building plans. Staff went ahead, ran the numbers, and advertised what we thought would be the most restrictive. So I believe that in our advertisement, we actually say that it is 2 feet to the wall and 0 feet to the eave. So 6 inches would be greater separation and therefore still allowed.
Yeah, all the eaves on the house, around the entire house, are going to be 18 inches.
But there's
How many? 8 inches, did you say?
No, they're going to be 18 inches all the way around the house. So they're not going to differ at any
But we're no longer in a mode where we have to ask, like, how will you get permission from the county to intrude into their airspace? You're back from the airspace now.
Yep.
So, and then your answer to the previous question suggests to me that aside from the bump out, there's more than 18 feet aggregate setback north and south. And that with the bump out, you're proposing 10.6 feet of aggregate setback north plus south. So there's a rule that you have to be at least 18 feet total setback on both sides of the house, right? Side A plus side B equals 18 feet. And my understanding from the staff report is that the 2 feet for where the bump out is, plus what must be 8.6 feet between you and your neighbor to the south,
Okay.
adds up to 10.6 feet instead of 18 feet. And so that's one of the ways that you're asking for relief. Am I describing this correctly so far?
I'm a bit lost, but I think what you're
Talking about the
describing-
18
Aggregate, yeah, he is seeking relief in the form of a smaller aggregate.
Correct.
From 18 feet to 10.6 feet.
That does make sense, but we also have to consider the aspect of that this is a corner lot. So does the 18 feet still play into consideration? Okay, then we would be.
Yep. So what it sounds like is it's 10.6 feet in the the widest part of the house on each side, basically.
It's really 2 feet instead of 25 because you're a corner house.
Yes.
Mr. Owen is describing an interior lot. We often talk to about corner lots as interior lots when we talk about relief.
May I chime in there? We actually do look at aggregates on corner lots as well. It's not typically an issue because one of the side setbacks is beyond most aggregates. It's only ever an issue when the reduction of one of those right-of-way or side setbacks is so drastic that it would be less than would required in the zoning district.
Gotcha.
So anyway, my point is that except in the bump out area, if the bump out were removed, the house would have 18 feet on both sides. I mean, sorry, the combined, it would have aggregate 18 feet.
I think the applicant said it would be 9 on one side, and I think it's calling out, 8.8 on the other, so it would be
very close to.
Very close to.
Okay. All right. Oh, yeah. So I visited this weekend, but I can't remember. Is there a concrete sidewalk that runs all the way down the Pershing Drive side on the county right-of-way?
Yes.
Okay. And so that sidewalk, there's a level sidewalk in between the curb cut and the garage, right? So it's not like people have to walk a little bit sideways to get across the driveway apron.
Oh, no, it's flat. Yeah.
And is it your intention to keep that sidewalk the same width it is and level?
Absolutely.
Okay. All right, those are my questions.
Mr. Chairman?
Ms. Malice.
It's a question for Mr. Rizzi. Was your denial based on what you had in the packet versus what was produced today?
The denial is based in large part because there is this easement for street purposes that is adjacent to North Pershing Drive that is unusual in this area, which for a use permit is difficult. Because of this easement, the setback that we calculate is much less than on surrounding properties, and that is the strict reason for staff's denial and the staff report.
Well, after further study, I went ahead and went downstairs to the health administration and so forth, and started finding out, and looking at the other houses and so forth, if they actually had an easement or not. So a lot of these houses around this area do not have an easement because the county has actually purchased that land. So this is kind of unique, which I kind of don't understand because my house kind of stands alone in this aspect that why wasn't that purchased, and therefore kind of alleviating the stress of, okay, now we have an easement, we've got to go back to it. No other house has this issue because that's considered, county property.
If I may, in our research, it's even more unique because you actually have both. We actually found a deed where the county did take some land that is actually that is now part of North Pershing Drive and this easement. So it's actually land taken plus an easement, which I don't think we found on any other lot.
Yeah.
It's very unique, which is hard when the standard is compatibility.
Mr. Chairman?
Mr. Owen.
So the applicant is proposing to relieve the community of a current adverse condition, which is a 0-foot setback from a sidewalk. And I think that it's appropriate to consider that accommodation from the current by right condition. It's actually chewing back some of the existing house that otherwise you might have the right to keep indefinitely. So while I agree with, I don't think staff's analysis is way off base. I think there's some give and take here in terms of the equities. So I'm inclined to approve, but not as advertised. I'm inclined to approve as presented rather than as advertised. Well, I don't think there is one provided. So we'd have to work off the approval as advertised and modify it. There
I
is?
think since we provided a denial, it's, yes.
It's advertised. We have to edit.
Yep.
Correct.
And I want to address the garage, because I think staff also objected to the garage separately. And I think that their analysis is also fine. I think it's a perfectly fine analysis. I think there's an unusual condition, which is that the rear neighbor's property, so first of all, it's a corner lot, right? So rear of a corner lot doesn't really, in general, the rear of corner lots are sometimes not what seem like the rear in reality, right? But here we have the additional issue, as you can see actually in the photo that's on right now, that the most affected neighbor, the one whose property is a foot away from the garage that's going to double in size, their house is on another street entirely. All they have is a long driveway that leads to the back of their house. So there's a very unusual, extremely unusual configuration of the other houses that make them much less damaged by a large structure so close to the property line. That's very unusual in this, in the county, and probably in this neighborhood too. So I think staff went by the book and analyzed it according to their formulas, and they gave us good advice based on those formulas, but I think there's this exceptional condition of the location of the neighbors' houses, which make it less severe. So I don't have a problem with the garage. And although I would probably, in an ideal world, have preferred just clipping off that bump out entirely, or putting it farther back than 2 feet, I think 2 feet is reasonable. And especially if we're getting it on the first floor, I think that's a big plus for the community and worth some trade-off. So that's sort of my general attitude about the situation.
Thank you, Mr. Owen. Any further questions of the applicant? All right, any further discussion?
I would like to try to edit the alternative resolution approving, but we have to edit it.
Are you beginning to propose a motion, Ms. Malice?
I have to figure out what to edit, but it's the beginning of a motion.
Okay.
So if we walk through it, it's to permit a setback of, is that going to be 6 inches to the eave?
Yeah, so I think it would be 0.5 feet to the eave and 2 feet to the wall of a building in the third line.
I don't see the wall.
No, you'd have to add it. So 2.5 feet to the eave and 2 feet to the wall of a building.
And is it that's the only edit?
You'd have to, in condition number 1, refer to the survey presented on June 20th, 2018.
That is.
I would want to add an additional clarifying condition about the distance of the wall to the right-of-way.
What would that be?
No portion, condition 4, no portion of the finished structure below the roof to be closer than 2 feet from the Pershing Drive right-of-way.
So that's belt and suspenders.
Yep. Basically, we have an existing structure, and then they're proposing to build more. And because the existing structure is by right, I just want to be super clear that if for whatever reason you get this great job in China and you sell the house with all of its land rights, whatever, no one has any question that we're talking not just about building the second story back 2 feet, but we're talking that at the end, no wall is going to be closer than 2 feet to Pershing Drive. So that's what I'm trying to clarify. Yep. To the sidewalk, to the Pershing Street Drive right away.
Okay.
What are we calling it? Well, in the
staff report, I often refer to it as the easement for street purposes adjacent to the North Pershing Drive right-of-way.
to the easement.
Street purposes. All right, I can move this.
Go ahead, Ms. Mallett.
I move that the Board of Zoning Appeals adopt the attached alternate proposed resolution approving use permit V11372-18-UP-1 with the following changes. The first sentence to read, the first whereas to read, the Board of Zoning Appeals has duly held an advertised public hearing on June 2nd on case V1, June 20th, 2018 on case V11372-18-UP-1 for special use permit application to permit a setback of 25 feet to the eave and 2 feet to the wall of the building instead of the 21 feet as required from North Pershing Drive right-of-way. That's the only change in that whereas. And then in condition number 1, change the date from June 15, 2018 to June 20, 2018. And add condition number 5, that no portion of the finished wall shall be no portion of the finished wall along Pershing Drive shall be no closer, well, I need a sentence there. All right, go ahead. Insert.
No portion of the finished structure below the roof to be closer than 2 feet to the easement for street purposes on Pershing right-of-way.
I want to include that in my motion.
Is there a second?
Second.
Mr.
And
Chairman?
if you got that all, Mr. Reese? Thank you. Mr. Owen?
I just want to, for the record, I think the motion's fine, but not all of the drawings that are applicable were actually presented today. The plat was presented today, but the architectural drawings were presented earlier. And so the point is that it's everything that was presented on June 15th, except as superseded by what was presented on June 20th.
Yes.
That's what we mean. And I feel like we don't need to do a formal amendment to all have that understanding of what that means.
The reduction of 2 feet on that one side.
Yep.
Okay.
I need a second. Do I have a second?
The second was Ms. Freshman. Any further discussion?
Hearing none. All in favor of granting a use permit
As
described in the motion by Ms. Malice in case V-11372-18-UP1, signify by saying aye.
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 All opposed?
And the ayes have it. Thank you very much,
Congratulations.
Mr. Jansen, for
Thanks for working along with it.
Oh, I really appreciate it.
And your extra community outreach too. That was a factor.
Thank you, thank you. Just one small clarification. That sawtooth is going to go away, right?
We adopted the drawing you submitted today, which has the fill-in.
Perfect.
So
Great.
it's the drawing submit, the plat submitted today with the architecture submitted.
Perfect. Great. Thank you very much. I really appreciate your time.
And if you would call the next case, Mr. Rissy.
Case number V-11381-18-UP1 is a use permit request by Ling Lin Lu, the owner, to permit a setback of 15.7 feet to the wall of the addition, 14.4 feet to the eaves from the rear property line instead of 25 feet, 21 feet to the eaves as required, regarding a new one-story addition in the R6 zoning district, premise known as 657 South Harrison Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions? Okay. And I have
Oh,
Mr. Owen?
I do have a question. Is it staff's understanding that we're being asked to approve something that's already been built?
That is staff's current understanding.
Okay, thank you.
Current understanding or knowledge? I mean, it is there.
Yes, we have photos that it exists in the current configuration.
Okay. Well, let's hear from, I think we're going to hear from the applicant has asked for some help with translation, and I think this is Nan Davison, who is applicant's sister.
Yes. Good evening, everybody.
Okay.
My sister.
Go ahead. I'm sorry.
My sister have very limited English, so my English is not perfect, but I'm trying my best here to help her.
Thank you. And you live at 657 South Harrison Street, Arlington?
Yes, that's my sister's house.
Okay. And your address is?
I live Forest Church.
Okay. All right. And your name?
My name's Nan Davison.
Okay. Would you give me your address so I can put it on the speaker slip?
Oh, sure. My address is 3405
3405
Fiddler's Green, Fiddlers. Green.
Fiddler Square?
Fiddler's Green, Green.
Oh.
Forest Church.
Green?
The color green.
Falls Church?
Zip code is 22044.
Thank you. Appreciate that. Go ahead, continue.
Well, number one, hopefully my sister will get her permit. And, my culture is we have to take care of our parents. My parents is like almost 80. And my mom have mentally issue, health issue, all kind of, problems. And so my sister is single. So we already get a care suite approval for my sister. So hopefully my parents can live with her until whenever, so.
So apparently, what can you tell us about what you know about this being constructed?
Well, my sister bought this house 2014, and it was like when he bought it, everything was there, and from the foundation to the roof, she didn't touch anything, and so like in back of the porch was still there, everything's there. She didn't put in any addition on the either side of the house or back or the front.
So she did
Ms. Malice.
She did not enclose the porch?
She did not put in any additional size. So she did close the porch. She replaced with window instead of the screen.
Okay. And her thinking was that that wasn't much. There were screens there. I'll just take the screens out and put windows in, and not thinking that now made a room.
No, this is her first house. She never owned any property before.
Okay.
Mr. Chairman.
Mr. Owen?
One thing that we're very interested in these kinds of applications is what do the neighbors have to say? What do the neighbors who are affected by the construction? And we received information, I guess your sister or you got signatures from 3 nearby neighbors saying, this is fine with us, we have no objection. And that's in our packet. We have 3 neighbors who
Yeah,
are.
I was walking around with her, and those neighbors did decide for her.
So my question is, it looks like, do we have a copy of can we put on the screen the tax map? Is that one of the things we have?
No.
This is, well, that's too bad. But the 3 neighbors we have, 2 are across the street from your sister's house?
Yes, 2 across the street from her, and 1 is on the side of her.
On the south side. But the addition, the porch or the enclosure, the thing that we're talking about is on the northeast side of the house. So the neighbors who said it was okay can't really see it. And then there's 3 other neighbors who are on the northeast side of the house where the bump out is that we don't have any information from. There's 2 neighbors in back that are on Greenbrier Street and the neighbor to the north. Did you try to talk to the neighbors in back or to the neighbor on the north side?
We thought it's only neighbors on her street, so we didn't walk to another street.
The reason why we care about the neighbors in the back is because the addition's in the back, and so the neighbors that are affected by it, the people that might have a different view or something, they're in the back, and so that's why we would care about that.
Addition on the back had a permit. I saw that 1960 something. I wasn't existing. I wasn't born yet. So the addition was already there. We didn't build any addition.
I understand. It seems like Mr. Rissi would like to help add information.
I can testify that I have spoke to someone who told me they were directly behind the applicant, who was unclear of the scope of the project, whether there was any enlargement or additions being proposed. Once I clarified that the application was for work that they actually were the ones that told me had already been done, they said they did not have any opposition. I spoke to another individual on the phone who said they also lived behind them. They didn't give a direct address, who likewise, once the scope was clarified, stated that they did not have opposition to the work that had already been done.
So the neighbor at 656 Greenbrier Street told you she was cool with it?
Correct.
And what about the 653 Harrison Street? This is the next door neighbor. If you face your sister's house, the one to the left.
Oh, yeah, we did it. We tried to lock her door. There wasn't anybody home.
Okay, thank you.
Thank you.
Thank you, and also Mr. Rissi for providing that neighbor outreach information. Any other questions? If not, the matter's with the board. Ms. Malice?
How did the application come about?
This came about because the applicant applied for a building permit for the enclosure in February of this year, and a zoning reviewer looked at the plans and said that it would need BZA approval.
But there was a building permit to do what?
For the work to enclose the structure. Again, the work had already been done, so they had applied, yes.
Do you know how that building permit came
How
about?
they got to learn that they needed one.
I
We can ask the applicant. Did you understand that question?
Uh,
How did you find out, or how did your sister find out that a building permit was needed?
Well, there was evaluation. Some neighbors called the county, so the inspector came over. That was back in 2016 or 2017. And we followed step by step, apply for the caregiver suite, apply for this, that, and it's really been struggling since the day she got a violation. We've been working on every single day something, I can say like that. But finally here we are after so long.
A neighbor complained?
The neighbor called the county.
Which neighbor was that?
I don't know. No one tell me.
Okay.
I wish I know. I can say, if you know, let me know. I can.
So somebody did complain, but it might have not been one of these?
No, somebody called county says there's construction going on. So we did, the county inspector came over, so you need a permit, so.
Okay.
Thank you.
So there was construction, and a permit was issued?
No, it was applied for.
Applied for, but then they bumped it to zoning.
Yes, they got a rejection comment from the zoning
And so
reviewer.
no building permit has been issued?
Correct.
Okay. And that's still yet to come?
After we...
That's
Yep.
right, it was. Yes, okay.
Anything else?
Thank you.
Mr. Melnick?
Okay, I'd like to make a motion.
I'd be happy to accept your motion.
So in case V1138118 UP1, I'd like to make a motion that the Board of Zoning Appeals grant the use permit request with the conditions as stated.
Is there a second?
I'll second.
Yeah, you got it, Ms. Malice. Moved by Mr. Melnick and seconded by Ms. Malice to grant the use permit in V-11381-18-UP1. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it, the matter is granted. Finally.
Thank you all very much. Thank you.
I'm sure you learned a lesson. Check first.
Yes. And, thank you. My parents were very happy. Thank you so much. Thank you.
Please call the next case.
Case number V-11382-18-UP1 is a use permit request by George M. Dryden, owner, to permit a setback of 18 feet to the porch, 16.9 feet to the porch eaves from the North Woodrow Street right-of-way instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from the right-of-way, and to permit a setback of 8.3 feet to the porch from the left side property line instead of 10 feet as required, and permitted aggregate side setback of 12.1 feet instead of 18 feet as required regarding the new front porch and new left side porch in the R5 zoning district premise known as 822 North Woodrow Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Mr.
Thank
Chairman?
you very much. Questions of staff, Mr. Owen?
Yes, is the left side porch here referring to the landing that's, would be midway back the house?
Correct.
Okay, thank you.
Let's hear from the applicant, Mr. Dryden.
Good evening. Thank you. We have nothing to add to the application. Thank you for your consideration.
Thank you very much.
Mr. Chairman?
Mr. Owen.
You got feedback from 3 neighbors. One that I was curious about that was not included was 827 North Woodrow Street. So this is across the street. So basically, there's 823 is across the street. That's the one a little bit to the right. And then the one a little bit to the left is 827. I'm wondering what the outreach was to that neighbor.
The neighbor directly across, so you're asking about the neighbor.
So it's the
left,
neighbor, in this photograph, it's the neighbor whose house is in the very bottom right of the photo.
About right. I did not contact that neighbor. It's a rental house. I don't know the landlord. I've never seen the landlord. And the renters are not often there.
Okay. I have another question for staff.
Sure.
In the proposed resolution, there's a condition, the proposed resolution, condition number 3, applicants agree the front and left side porches shall not be enclosed. Sometimes I thought we say built over or enclosed.
Yep.
Is there any reason why we wouldn't say that here?
No.
Sir, applicant, do you have any objection to a restriction that you would have to come back to us to build over those porches?
No, sir.
Okay, thank you. Mr. Chairman.
Thank you, Mr. Owen.
Do we have speakers? Any other speakers?
We don't have any speaker slips.
I'm prepared to make a motion.
I'd be happy to accept it.
Mr. Chairman, in case V-11382-18-UP-1, I move that the Board of Zoning Appeals adopt the proposed resolution approving the use permit with a change to condition number 3, that the applicants agree that the front and left side porches shall not be built over or enclosed.
Thank you. It's been moved by Mr. Owen and seconded by Ms. Freshman
To adopt a resolution granting
the use permit in V-11382-18-UP1 with the conditions amended that the additions not be built over or enlarged. Is there any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it and the matter is granted. Thank you for coming. Presume that's your builder he brought along. Thank you, too. Please call the next case.
Case number V-11383-18-VA-1 is a variance request by Alan Bowe and Margaret L. Windus, owners, to permit a setback of 12.3 feet instead of 16 feet as required based on the requirement for a 20-foot separation required between main buildings and a 4-foot encroachment allowed to window wells regarding the addition of a new window well in the RA 1426 district, premise known as 3525 South Stafford Street, number B. Staff recommends that the board adopt the attached proposed resolution granting the variance request with conditions. I'd like to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. It is an anonymous letter of opposition.
So,
Madam Chair, I just wanted to point out that this is an anonymous thing, which we typically don't.
I think we previously voted not to accept into the record an anonymous communication. So I guess I would move that we not accept that.
Can we exclude it from the record?
Exclude it from the record. That's my motion.
Second.
Any discussion?
I'm sorry, sir, could you speak up? My hearing isn't the best.
Someone sent in an anonymous letter opposing your project, and we're saying we won't listen.
Thank you.
We won't accept it. There's a motion on the table. Any discussion? All in favor, signify by saying aye.
Aye.
Do we have a second?
Opposed?
So,
It was I'm sorry, the motion was made by Mr. Owen and seconded by Ms. Freshman, and it passed by 4-0. The chair, Mr. Smith, was out of the room.
so the rationale is that the information of who sent it is foiable. I mean, it's in staff's hands, and for it to be excluded from us just doesn't make any sense.
Okay.
So any questions for the applicants? I mean, for the staff before we start with the applicant? Okay, Mr. Windus? Are you Mr. Windus?
Yes.
Mr. Bowe.
Mr. Bowe.
Oh, thank you.
Oh.
I was hoping for a larger audience tonight.
Well, that's what you get for
Mr.
waiting.
Chairman, members of the board, my name is Alan Bowe. I have been a resident of Arlington Glen for over 40 years. My wife, who's sitting behind me, was an original owner before I joined her. I'd like to emphasize that the project that we seek approval for tonight is one of safety for our unit. It is an egress window that will allow us to come into conformance with Arlington County's requirements for secondary exits from basement bedrooms. This installation would then allow us to use the current den as a bedroom. I might note that there have been, at last count, over 8 to 10 of these units installed in Arlington. This is the first one requiring presence before this board for appeal and review due to the 20-foot offset requirement. I believe that the package supplied by staff is fairly comprehensive and leaves nothing more that I can add, so I yield whatever time I have back to the board. I must ask that I'm going to ask my wife to help me because my hearing is not that great. This is Margaret Windus.
Any questions for the applicant? Okay, thank you, Mr. Bowe.
Thank you.
You may sit down,
All right.
and you can take over.
Thank you. Thank you very much, Madam Vice Chair.
Yeah, we made a motion while you were gone, so.
I understand that, too.
that this anonymous letter was not received.
Mr. Chairman?
Mr. Owen.
So I just have a comment about this. My biggest concern for this application is whether or not it meets the variance criterion about whether or not the situation is not so general or recurring as to make it reasonably practical to formulate a regulation which can be adopted as an amendment to an ordinance. And the staff has an explanation here that it's relatively rare for there to be by right residential projects with multiple buildings that would be subject to this particular regulation. So I guess my inclination is to sort of roll with it for now. I'm not sure how rare it really is, but this is the first one that I've seen. So this isn't like the R2.7 bump outs that we've seen. Is this R2.7? But this seems to be of a different character than the more voluminous bump outs that we've been getting repeatedly on other sites. So I guess I lean toward granting this particular one, but if we were ever to get another one, then I would seriously question whether or not it was recurring and susceptible to a general ordinance change.
It says here, in this district, you can't do that. So it has to be a variance.
Right, and that's my point, is that with the R2.7, we have another one coming up next, right? The very next application is the kind that we previously had voted to deny, and that the board is actually, there was a political movement, and the board, in fact, is studying it, and so the question is the one in this application like that, or is this really a weird one-off thing? And I'm a little skeptical about whether or not we might get 40 other Fairlington residents who want the same thing, right? And at a certain point, we would have to question that. So that's my main question, and my current leaning is, particularly because I actually have never seen, and I'm new here still, 2 years.
I haven't seen anything like this, and I've been around a long time. Individual houses seeking the egress window wells. We've seen a number of those that need side yard setback relief, but the a property like this, no, I've not. We did do, this is a long time ago, in this neighborhood, we did do some English basements in that section along, I can't remember exactly the street. Mr. Lawson, I think, was the lawyer on that 15 years ago or so. That was that's about the closest to anything like that, and that was subterranean too. But it was for the English garden kind of a thing versus this. But in any event.
So anyway, my bottom line is: fool me once, shame on me. Fool me once, shame on you. Fool me twice, shame on me. Like if I see another Fairlington window well, then I might not vote the way that I'm planning to vote tonight on this one.
Mr. Melnick, and then Ms. Freshman.
But, in light of what you're saying, I think it is important if we have evidence, or something in our presentation to show, that this condition is met, because it does set a precedent. You know what I mean? Because then the next person will be like, well, you stated that these conditions were met. So it'd be really hard then to turn it down. So, I'm kind of stuck on that condition too. And does the staff, because the staff I see in this report that the report says it's not very generally reoccurring. However, it is, it is an area, it's a development. That is the question, how many buildings, or developments are there like this? Do you have any input about that?
I can tell you I did a brief search of the history, and I couldn't find another application to this particular section of the ordinance. Of course, this particular section of the ordinance has only been this particular section of the ordinance since 2013, when they reorganized everything. But even then, we haven't seen one in 5 years, so even based on that limited information, I would say it is not a common condition in the county.
The challenge is, even if it's just Fairlington, if it's all of Fairlington, that's a lot.
Right.
There's a lot of units in Fairlington. And so I think that's the conundrum.
I would say, though, that all of the...
By all means. If you use to the microphone.
Mr. Bowe, please come to the mic. Welcome. Again.
I'm sorry. You were inquiring about the size of Fairlington. South Fairlington is 1,700 units. With the north side, that's over 1,700 in addition. In regard to the similar type situation here, in my own village, I've seen 10 instances. If you multiply that by 5, there's 50 in the south, and God knows how many on the north. You're likely going to be faced with this question again.
We're likely to, won't we repeat that?
He was arguing against himself.
I was just going to say that.
I mean, I thought there are a lot of units like this.
Saying 50.
Yeah. But the the Townhouse Association on the board on which you sit has said it's fine with them, but I can imagine there are a lot of other, are these configured where they're a first floor, a second floor, and a basement, each of the units? No? Most of them are? Okay. So they're townhouses that are just old, they're vertical. These photographs, are these from existing window wells that are in Fairlington that we see? Right. Where are these from? This sample, where is this? This is in Fairlington right now.
Fairlington Glen.
Photograph with, that's Miss Wenda's.
Adjacent village as a sample. See, it's my wife standing there to lend.
And where is this?
You know what?
In Fairlington.
Oh, in Fairlington, okay. So someone has done this.
Well, as I said, there's been 10 unit installations in South Fairlington so far.
But they didn't require trips to the BZA.
Right. So the question in our mind is, how many more people, in order to put in window wells, would need to come to us like you have? That's the question we're wondering about.
I looked at my own building, and as I said, there were 10 instances of passageways of this type. If you multiply that by 5 different villages, it's 50 in South Fairlington. As I followed up, God knows how many in North Fairlington. I don't know.
Just for the record, you're repeating what you had said into the microphone, but thank you.
Thank you.
It's not clear if he means that have this, that would need to come.
That's what he's saying.
Yeah, that's what it sounds like.
He's saying that there might be 100 more
That need to
in all of Fairlington that might need to come in.
Out of 1,700. Mr. Rissy.
If I may just add a part that I feel like we may be glossing over in the staff report, another compounding issue on this particular lot and a reason why he isn't looking to add a window well in the rear is because there are underground electrical utility lines that would prevent him from the by right option available to him that may not be available or...
Chairman, I move that we adopt the attached proposed resolution approving the variance request with conditions in case V-11383-18-VA-1.
Thank you, and thank you, Ms. Freshman. Moved by Mr. Owen, seconded by Ms. Freshman to grant the variance in V-11383-18-VA1. Any further discussion? Hearing none. All in favor?
of granting the variance signify by saying aye.
Aye.
All opposed? And the ayes have it. Congratulations. Thank you very much.
Thank you, Board, very much. You're certainly our guest if you wish to come and see what an egress window looks like when it's installed. Thank you.
Okay,
Have a good night.
you. And the last case of the evening.
Case number V-11384-18-VA-2 is a variance request by George Mercado Boza and Alidia F. Rios de Mercado to permit a rear two-story addition to an existing non-conforming building in the R27 district and permit a new addition to exceed 50% of the aggregate floor area of the existing building on a lot that does not meet the area requirements for the R27 zoning district, premise known as 816 South Highland Street. Staff recommends that the board adopt the attached proposed resolution approving the variance request with conditions.
Thank you very much. Questions of staff?
Mr. Chairman?
Ms. Malice?
Mr. Rissy, was the applicant aware that this board had denied two previous applications?
I talked with the applicants in this situation after they made their application, discussing previous case history of the board, tried to make them aware of options, and they decided to proceed.
Thank you. So, let's hear from the applicant.
Hi, my name is Daniel Mercado Rios. I'm the son of Jorge and Aleda, and I'll be speaking on their behalf.
Welcome, Daniel.
Thank you. Thanks for having us. I'll be pretty brief. You guys have the application in front of you, requesting the variance for a permit for the new rear story addition. The new addition will conform with the zoning setbacks of 25 from the rear and 10 to the side. We have letters of support from the adjacent neighbor that's exactly next to us, sharing the party wall, and also the neighbors to the right of us and to the rear of us. And I'd be happy to answer any questions or clarifications.
Okay.
Have you, yes, I'm sorry, what was your name again?
Daniel.
Daniel, have you read the staff report?
Yes, I have.
When did you have a chance to read it? Just tonight or before tonight?
A couple days ago.
Okay, so you saw in the staff report that there's a discussion about how the county board has directed the staff and the manager to review the zoning rules for this kind of zoning category, and that there's this year supposed to be a review and maybe changes to the zoning that would allow more flexibility to build something like this. Okay. Do you have a sense of how if you wanted to participate, or if your family wanted to participate in that, how you would do that, how you would get in touch and say, please change the zoning to allow this?
I'm not aware of how to get in contact with or be a part of that decision.
Okay. 703-228-3525. No, we'll work on that.
I mean, essentially, this is as the report discusses, a reoccurring issue, and that now there is attention being paid to it by the lawmakers in the county, with the hope that they will relieve
the amount of
individuals like yourselves burden of trying to go through a variance process and make it possible to modernize these woefully small dwellings. I lived in one years ago myself, so I know exactly what
I guess
it's like.
my understanding with talking to my parents and a couple of our neighbors is that this is the first, that some of them have done additions before and they haven't had to go through this process.
Oh, no, they did.
They did? Well, okay.
Or they should have.
Yeah.
Yes, they didn't. It's a problem.
It's a problem.
Okay.
But we've seen many come through, and they were more readily accepted, but it's gotten to the point where it really demands a change in the law.
Yeah.
versus dealing with individual cases. And there was a case about a year or so ago which garnered a lot of attention, some media attention. There was a write-up in one of the local news organs about it, such that it did prompt, I think, the county to look at how to address this. So the earlier question was, did you know about that? Because maybe delaying may have been a better course of action, because even though there is the staff has recommended approval, it's been very difficult to get these approved in the recent past.
So go ahead.
Mr. Owen.
So,
And, no, Ms. Malice, then Mr. Owen.
so what we face is that we have rules
Yeah.
for approving variances, and cases like this don't meet those standards. And so we are bound to follow those rules. And so I believe that we would not be able to support the application.
And again, as just further elaborating on what my colleagues have said, the state law, the state of Virginia divides responsibility into saying if it happens over and over and over again, then the county board needs to make a rule. If it only happens one time, then the Board of Zoning Appeals can make the exception. And we are forbidden, the state law actually forbids us to grant a variance if it's something that could happen over and over again on similar parcels. And we've seen lots of these kinds of applications, and so we can't deny, and that's what we were talking about on the previous application, how often is this going to happen in Fairlington? If it's going to happen 100 more times, we might have to say no and ask the county board to develop a rule. The good news is that somebody who we already denied a few months ago was understandably upset and started a political movement. And so there's already a petition and, there's already something in the works. So you're way ahead of the game in terms of you don't have to start your own political movement to go forward with this. You just have to join the one that already exists. So if we deny, which I think is likely, it's not the end of the road, because there's a decent chance that within a year, the board will change all the rules for everyone, including your family. And if you participate in that process and talk to them about what you're trying to do, those rules, when they change, they might even be changed in a way that particularly accommodates you, if your family participates.
Any further questions of the applicant's representative, of the applicant? Any further discussion? Let me ask staff, do you know at the pace that this review that you write about is being undertaken, the zoning work plan?
I, of course, can't say anything definitive about when the board may approve changes to the zoning ordinance, but the time frame that has thus far been discussed is sometime this fall to get at least a phase 1 of changes made, with additional time needed for phase 2.
Because this applicant has paid, let's look at the dollar amount, $358.05. And if this is continued for 6 months, there may be action that could make it moot, and they could ask for a refund, reimbursement.
Withdrawing the application?
Or withdrawing the application. But I see you raising your hand. Go ahead, Mr. Risi.
Just, again, can't speak definitively about what changes will be made, but at current juncture, my understanding is there are portions of this application that would not be remedied by at least phase 1 changes to the zoning ordinance.
So everybody's in that boat.
Well, no, this application is a little bit different than the ones that were denied in December. This application involves a request for an addition of more than 50% of the existing structure, which was not a portion of those applications.
No, it's not those, but what we find on the south side is just that. They're all substandard, and so that puts them into, and generally, any addition, you could put a one-story on the back that would be less than 50%, but in general, everything we've seen in comes in at more than 50% because they are so small. I mean, what is it, 800 and change square feet for the whole thing? So, in any event, so you're suggesting that even if the phase one ideas are implemented, this applicant may not get any relief from that.
It's all very theoretical.
They may get some relief, but not enough to not need to come before the board.
I gotcha. Ms. Freshman.
I agree with the staff report, and I'm going to move for approval.
Is there a second?
Guess not. Okay.
Well, I would second it, but it doesn't seem like it would make a difference, Ms. Freshman.
Okay.
Because no one else would second it, so.
Sorry, for the record, you would, but you are not?
Yes, correct.
Okay.
Mr. Chairman, if I thought it could, I'm sort of theoretically open to an extremely long deferral, like a year or two, but I don't, with this applicant, I just worry that would prove more traumatic than a denial. You know, that it would complicate the situation because this is I just don't think there's because I think the same issue will be presented whenever they come back. You know, irrespective of how the county board does change the ordinance, whatever's left, there's no claim that there's something special about this property that's different from most of the other R2.7 lots. So I would, if the applicant wanted a really long deferral that was going to definitely last longer than the planning process, I guess I would give it to them. But if I were their friend, I wouldn't advise them to ask for that because I just don't think it's going to do them any good.
Well, let me ask the staff this. Under what conditions do they get a refund of the application fee?
At this point, they really aren't entitled to one because the application has been reviewed by staff, it's been advertised, it's been in front of the board, it's had its full.
Right. And that's why I would defer it doesn't have to be a year, I would say 6 months, because we can revisit that again. Because, well, you know, $358.05 is not a lot of money. It's, you know, it could have been expense, and then to have to come back for something less than what they're asking for here under conditions of a changed ordinance that may be more amenable to an application. I would hate to see them out $700 to do that versus the $358.
If I thought there was any version of, like, for me, I'm trying to think of, like, what's the path? What does the county board do or not do that then leads to an approval? And I'm just not seeing a path because it's the same underlying problem, no matter what the county board does in the meantime. Maybe the county board gives them rights that they want to exercise, in which case they're done and they don't want to come back. Or the county board doesn't, in which case they come back, but we're facing the exact same legal issue. I don't think the county board can do anything.
Well, yeah, they could do a lot. They could change this 50% to 75%. They could, and they may qualify under that.
Yeah, and that's what I'm saying. The county board could grant them the relief.
Yeah.
But the only reason they need to come to us, but then they would just take that relief. But any further relief they would ask for us has the same problem that we have today.
Well, I guess, no, I would say it differently. I would say that if they were, that if it was so close the argument that the staff has made in this application, I would adopt, that if they were very close, then it would be unreasonable to deny them relief under the variance law if it were changed and it was very close versus where it's not close here. That's the difference that I would see.
If Mr. Lawson were representing these people, right, or they were really good, they showed evidence. If I had a lot of indicia that these guys were like spec builders or some people who really understood the zoning ordinance and were comfortable working in it, then I would say, sure, that, there might be this narrow path that I can't see that maybe you can see. But I just don't want to drag these people back here in December and do the same thing and have them spend another, they'll come first on the agenda, but, I don't want to drag them back to 2100 for no reason. So anyway, I move denial.
I have a question.
Yeah.
If, like you were saying, they do move it to 75% or closer, it's still we still have to submit the application and everything again because we can't do an addition because our house is in a non-conforming. It's non-conforming due to the current setbacks, so therefore you can't make any changes without a variance. At least that's my understanding.
Yes, currently that's what's in the ordinance. That is one of the things that is being looked at being changed.
I know that you mentioned there will be other changes, but those changes won't really affect us. Do you have any idea of?
I can't, especially on record,
Okay.
say with any definitive resolution as to what changes will be made. I can talk with you. Well, let me just say that the current plans do seem like they will allow for some additions to be made to two-family buildings as well as our 2-7 zoning district buildings that are more or less in line with the allowances that are available for other single-family zoning districts and one-family buildings. That seems to be the direction this is going. But phase 2, the part that requires more study, really is going to be more the portion that gets into the percent coverage. Planning staff just isn't sure about how many units that may impact and what overall impacts that may have for the county.
So I think because it is when the legislature has a fresh decision on what's appropriate, I don't think that the next step is for applicants to come and ask us for more, because that's a fresh decision. So to have this applicant come back when they've been given more, and then by the board, the county board, and then come to us and ask for more, it seems like then we are not really acting in the spirit of what was just adopted by the entire community. So I'm also concerned about dragging this out for the applicant because I don't see what a deferral really gets you.
Well, it sounded like they took over. They're thinking about eliminating the substandard lot size.
Mr. Chairman, my motion is
I second the motion.
I move denial in case V-11384-18-VA-2.
Okay, motion's been made and seconded to deny the variance request.
May I speak, please?
My mother would like to say a few words.
Before you say your final decision, I would like you to hear me a little bit. We were waiting to do this addition for a long, long time. We didn't put the papers before because we were not ready financially, but now we are. And I understood that two of another people who request do additions was denied, but now in the neighborhood or the streets where we live at, by the time we left it here, the application, everything, we didn't know that it was denied. And it was when we already leave the application. And we really, we were thinking we will find this, we will say steps that.
It has nothing really to do with the timing of your application. It really has to do with how this is being applied now. There were folk granted these in the past. There's no question about that. Now that's not being done, and that's why you had these motions are being made. It's nothing to do with the timing of your waiting at all. It's
If you had applied 6 months before or 6 months later, same result. It's not about the timing of your application.
maybe 3 years ago it would have been different, but not.
But mostly in our street and the back of our street, we have most of the same type of house that we have. They have their additions.
Yes.
They probably had them for a while, though.
And the last one was just, the two last one was just last year, no, this year. And they didn't even knew about that they have to look for to approve the variance.
Well, they had to get a building permit. And if they got a building permit with, and their structure is just like yours, then the building permit folk probably made some mistakes.
Wow.
I would suspect that wasn't the case. That if they built something, they built it with permission.
Yeah, they did with the permission, but they didn't go through the variance like we are doing at this time.
Well, probably their conditions for their land was different than yours.
Mostly the houses that are in that street on the back are the same.
Yeah, it's. I think all of us understand how unfair the situation seems seems to you, and I think if it's just. I think we understand how unfair it seems because different people seem to be allowed to do different things. But what we're doing is we work for the court. We work for the government, and we are only allowed to do certain things, and we're specifically not allowed to grant a variance that is something that 1,000 other people could ask for. We're just not allowed to do that. And so it doesn't have to do with the timing. It doesn't have to do with what else is in your neighborhood. It's a rule that the state legislature has imposed on us as a Board of Zoning Appeals that we have to let the county board do it instead of us. And we don't even agree amongst ourselves whether we're bound by that rule, but a majority of us does. So, you could appeal, I guess, our denial to the circuit court and test which half of us are right if you want. I don't recommend that either because it's more money, but I think we understand how unfair it seems, and that's why other people have already gone to the county board to ask them to do this review. And I strongly encourage you to get involved in that and tell the county board and the county planning staff what you want to do and why it's a good idea. And there's a distinct possibility that the rules will change soon to let you do what you want to do.
There is a motion on the floor that's been properly seconded, and I think we've exhausted discussion. Unfortunately, a motion was made and seconded, and I can't really entertain any more discussion from the public or the applicant either. It's only discussion about the motions that have been made. So, any further discussion on the motions that have been made? Hearing none. All in favor of the motion signify by saying aye. Aye. All opposed?
No.
Nay. So, unfortunately, the denial was passed by a 3-2 vote.
No, it's okay.
Thank you so much. Thanks for the time.
Thank you so much.
Thank you.
And
thank you, Danielle, for...
And Daniel, I do encourage you to talk again to Mr. Rissy and get from him information about how to participate and react to this because, it's not unreasonable what you've asked for.
So, and now we have the minutes before us.
I move approval of the May 23 2018 minutes.
Second.
Thank you. It's been moved by Ms. Freshman and seconded by Mr. Owen to approve the minutes as presented. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it. The matter is granted. Oh, you weren't here.
You forgot.
That's right.
I move adjournment.
Last month?
Yeah.
Yeah. I forgot that you weren't here. I'm sorry.
Did you remember that?
Oh, no, last month. Yeah.
So we're-
In just in reviewing these minutes, I didn't.
So we're on for 6 o'clock next month, right?
That's good. Yeah.
Okay.
To talk about bylaws and,
We should be communicating in the meantime.
Yes.
I moved adjournment, but nothing happened.
Second.
Ms. Freshman moved to adjourn. Is there a second?
Second.
Mr. Owen, seconded. All in favor?
Aye.
Signify by saying aye.
Aye.
The ayes have it, and we are adjourned. Thank you very much.